No, execution of what?
Of judgment.
Huh?
Execution, there one MSCT case award has been passed. We are in appeal. They are also in appeal.
Okay.
Initially,
Insurance company is also
appeal. Claimants have also filed appeal.
Okay.
Initially, stay was granted. Thereafter, both the appeals were tied together to be disposed of. Thereafter, assignment changed. So, stay order could not be extended. And the assignment is not.
When Monday?
Today, before rising, Millers. I have intimated the other side counsel.
Today, then it is after notice or?
After notice. I have intimated the other side counsel.
Subject to he is appearing, then only I'll do it. I'll stay for a week or so that.
No. So you'll also take it up next week for disposal.
It is rising out of 161.
160 is 166 application.
166. Okay.
You'll also take up next week for disposal.
They have asked for you have asked for announcement.
No, I am for the company. They have asked for announcement. I have challenged our
company. You are the owner of the vehicle.
No, I am for the insurance company.
Insurance company.
Yeah.
So what is the big deal? Insurance company. Why should I hear? Insurance company, you pay, you recover it. No, I thought you are victim.
No, victim. Millers.
All right.
I will not recover. Millers, it will be reduction. Between the insurance company and
you have a right to recover.
No, well,
insurance company, no. Yes, next.
Millers.
Monday.
Yes.
Millers, court number.
I thought you were a victim.
No. Victim, they are also in appeal.
What insurance company, you pay something and you recover subsequently? Why are you?
No, I cannot recover from the claimant. No, I can recover it from the owner if there is a violation.
Either from the owner or from recover. Right of recovery is always.
No, always that as against owner, not against the claimants. Victim.
All right, Monday before.
Court number 3 matter. In pleading for divorce, the wife's counsel has not been granted proper opportunity of cross-examining the husband, and it has been posted for argument. So let it come on Monday.
Monday that court will be there.
No, that court will not be there.
Why are you pressurizing? This court is already.
No. Next week also he will not be there.
Court number 3 will not function next week also.
I'll just see.
Okay. Matter, your lordship. Criminal case. To NBW matter.
NBW.
Maybe pardon to make a mention. Plus the batch of vigilance matters. State council also here. Fix it at 2 p.m.
What do you want?
To fix it, all the matters at 2 p.m. Millers.
Yes.
Today 2 p.m. Millers.
Today you are doubting that 2 p.m. will not come.
Millers, they have been listed as separate items in the cause list.
It will come at 2 p.m. We'll see.
That's all. That's
Let us see where we are reaching.
And yes. two matters out of the batch have been left out for which memo I have given. They may be.
They are not listed, then how can I take it up today? Main point I'll decide and that all the matter will be disposed of.
Yes.
We'll see. Yes.
May I be pardoned to make a mention, my lord? May I be pardoned, my lord?
Yes.
My lord, these are all fresh admission matters of court number 3. Yesterday also I made a mention before Honorable court number 3, before Honorable Justice J.S. Sarpathy. His Lordship was pleased to observe possibly he will not be even available next week. Now, the matter arises out of family court proceeding, 4 fresh admission matters, 3 writ petitions and 1 RPFM. The difficulty is, my lord, now in the trial court, they are not granting time. Now, this matter was mentioned long back, maybe 15 days back. Despite
what is the pressing urgency?
Urgency is, my lord, in one case, I am saying the proceeding itself is not maintainable for want of jurisdiction and the trial court is posting it for evidence. The other case, 2-3 cases relating to maintenance, where, my lord, my fate should be decided because now the execution is staring at me. So therefore, my lord, I made a mention matter has come in the list because his lordship is not available. It has not been listed.
Wednesday.
Next week, I am praying for next week, not today, my lord.
Okay, next week you just.
Time permission is filing it. All the memos.
You give the memo. Next week, 17. Yes, Mr. Das.
073. Your lordship, that matter, your lordship.
Item 66.
66, my lord. May I pray for after vacation? I have taken consent from my friend from the other side.
He has taken 66 consent for the
after vacation.
66.
Posted the matter, directed the matter to be listed.
Is there any stay? No.
No,
okay. Yes, Mr. Mahapatra. Yes, Mr. Mahapatra.
But that criminal miscase 3073,
Yes,
my lord, one criminal miscase 3073, your lordship
Yes.
directed the matter, considering the urgency, directed the matter to be listed today for fresh admission. But in fact, that matter has not been listed. All the three matters, due to the pendency of this criminal miscase, criminal proceeding, the petitioner is suffering from service issue and she is going to retire on the last of the next month.
so what is the
My lord.
pressing urgency to be listed next week?
My lord, urgency is that next week, because your lordship has post the matter, because today your lordship considering the urgency,
That's right, but for some reason it is
But
not
still-
listed. I don't know what is that. And give the memo, we'll see. Give the memo, we'll see.
May I?
You got memo? Okay, just check it
My
up.
lord,
why it is.
I'm my associate is there. He will hand over.
Yes, I got it. I got the memo. We'll check it up.
Fresh admission. I pray your lordship will say fresh admission.
Yes, we'll check it up. Yes.
Can you mention item 1 to 9?
Any?
Lord, item 25.
Acha, then no. Page by okay.
Item 3. I pray for an adjournment.
Item 3.
Opposite party is also.
Why are you seeking adjournment?
Lordship, my senior will.
The problem is you are not able to list fresh matters because we accommodate all these matters and you people are asking for adjournment. And thereafter you mention also adjournment to March end.
Obvious.
March end and April, those who are asking. And wait for that. On request, on the Land Council for the petitioner request to adjourn the matter to the month of March. On your request, yes.
Item 10 to 21.
Supposing the liquid.
Well, I don't know.
Land Council for the petitioner seeks an adjournment till March.
Well, item number 6, kindly put up this matter after vacation.
Same. Same also. Yes,
Item 10 to 21.
yes.
22 to 35.
My lord, item 25, my lord, prefer next week, my lord.
Same.
Fine.
April. March, April. Yes.
Item 36 to 41. 42 to 47. 48 to 53. 54 to 60. 61 to 66.
Item 63, my lord, on behalf of Mr.
ये सी जो इंश्योरेंस वाला मेरे को चला मंडे को ही ना yes.
Item 63, my lord. On behalf of Mr.
63.
Yes, madam.
Yes.
On behalf of Mr. Milan Karungo, kindly adjourn this matter
This
after.
is 2016 matter.
Yes, my lord.
On the ground of non-availability of senior counsel, it can't be adjourned. You arrange someone else. If one senior is not available, other seniors are available. Senior counsels are not fixed. You can engage anyone. There is no interim order.
Yes, my lord. Interim order there.
No, there is no interim order. Where is the interim order?
Further to regarding state.
Huh?
Miscase 882 by 60.
Hey, item
Item 63.
63. Where is the interim order?
Miscase
Interim order is there. No. Last 2 dates there is no interim order. Simply adjourn order. There is no interim order. On 22/10/2024 there is no order. And thereafter 6/12/2024 no order. Simply adjourn. I have not extended the interim order.
Miscase 882.
Where is that? Proceeding just see.
I'll check.
Just see both the proceeding and the. And on 7/10/2024, the order was by way of last opportunity, this matter is adjourned to so and so. Thereafter, again, it is adjourned to 22/10/2024. Again, a request. And thereafter, again on 6/12/2024, again request.
Last one was 1612.
Yes,
Thereafter, no interim.
no interim order, simply adjourn. Put it in the February. Yes.
67 to 72. 73 to 78.
Well,
Item one.
May I pray, my lord?
Yes,
Here the challenge to the rejection of my discharge application. And briefly, my lord, I'm giving facts here. My father was a public servant who was serving in the relevant period of time as deputy secretary to in the secondary board of education.
yes,
Then there is an investigation for disproportionate.
your father was posted.
Yes, ma'am.
Yes.
There was an investigation for disproportionate asset, and the check period was from 2nd of July 1971 to 4th of April 2012.
71 to 12.
2012.
Okay.
Now, my lord, we are in a family of 6, and my father, my mother, me, my wife, and my younger brother, all are living together and all are employed. Even I'm also a public servant, but since the matter is,
You are also a public servant.
I'm also a public servant, but not tagged as a public servant. They have stated categorically that this check period is prior to my joining as a public servant. So I'm now even implicated as an arbiter.
109.
E109. I'm the son, eldest son, and I doesn't have it. Post investigations, I found out 38%.
During the check period, you were a student.
No, I was about to. I have joined in those in 2012. I've completed my degree engineering, and then I was doing some business. I'll come back to those facts.
Yes.
So post investigation, they found 38% of disproportionate assets. This is the, and only I am being included is an arbiter.
Yes.
My lord, all of them have independent income. All of their income has been taken as a whole. Each individual who has been serving in different departments, their income has also been taken into consideration.
Let us come to the charge sheet. What are the property you have in your name? It's there.
My lord,
Come to the charge sheet. State it.
the allegations against me that I have purchased one JCB, that excavator through loan and a Jane car.
Let us see.
Yes.
What are the properties?
Your lordship kindly have
You,
that.
you are, what is your name is? Your name is
Mine.
Trivacho.
Yes, my lord. Sivacha Dholai.
Trivacho. Okay. Yes.
And
Which are-
before your lordship go to then another aspect here. The lone public servant who has been charged has been in the meantime died. So the question is that now whether this proceeding can continue against me, but I'm admittedly not a public servant, and the original charge under section 13(1) and
Now you have been prosecuted for 109.
109, not under the.
Yes.
So now the public servant is dead, pre-charge. Even prior to the charge is
Yes.
when he is dead.
Yes.
So that's the first situation. And the property,
Let us come to the properties.
my lord, property. Your lordship can have that. In the affair, they have mentioned that as page 15, movables, immovables first.
Yes, yes, Mr. Marana, just show me which are the properties.
You will also kindly, I have given.
Property is in the.
These are free fall allegation.
Mate copy diyan.
No, 1 minute. Just property, just show me.
Property you will also kindly see page 5.
3.
Page 5.
Mate copy diyan.
সেটা চার্জশিটে যাহা তুমি খালি দেই সর্ট খালি
আরে গোটে যাহাটা বি বড়
তার চার্জশিট তুমি লিখো
যাহাটা বি
Written submission, are you relying upon written submission? Then give it to me.
চার্জশিট
Mr. Maharana has filed a written submission. Written note of submission, and the advance copy of the same is supplied to Mr. Rath. Lease the matter for a year. And you have a difficult case.
My lord, I'll
Very difficult.
absolutely nothing in there. There are double calculations of my look, like my lord. There is an asset.
Perhaps I can't go into.
I'll show you from the Honorable Supreme Court judgment. There is a calculation. First, the public servant is not dead. There is a line of judgment, including that Bofor's case and Honorable Apex Court, that the non-public servant cannot be prosecuted after death of the public
The
servant.
principal accused goes, then the debtor also goes.
Goes, yes, ma'am.
That's your
because that cannot be proved. That provision. That's number one. Number two, my lord, what is
Because he can't prove his innocency.
yes.
So therefore, the aider.
Yes, my
cannot.
lord. How can it? That's number one principle. Number two is, my lord, I'm an arbiter. I'm his son. My educational expenditures, my has been taken as there. Look at the figure. That
No, the property which are there
property-
in your name, you have to defend that only.
my lord, they
You can't defend your father.
no, my lord, they themselves have defended it. I did not require to defend it. They themselves have defended it. That-
Okay, just see the written submission.
my lord.
Give a copy.
And the-
full contention hଉଛି
and the third is my lord, allow me.
internal expenditure payment kale kahi repayment ta kahi expenditure dekhele asset ta puni kahi dekhele mane
My lord, look at
it's a
this.
complete
Look at the
Now,
situation.
it is a-
My lord, I
I understood what you are
have
saying.
taken 100 rupees loan. That is shown in my income. 100 rupees assets is shown.
Huh.
Now, my lord, 200 rupees repayment. I can understand the interest part is going as my expenditure.
Hmm.
Income, interest is the expenditure.
But what is the source?
My lord, source is I have loaned it.
Once you say that you had an independent source, you have to prove it.
That is, they have to, my lord, first, I am a income tax assessor in the year 2012.
You are a student, where from?
Before that, my father has given, exactly, my lord, I am drawing it. It has been calculated in the hand of my father.
How can you be an income tax SSC being a
In the year 2012, when I started my business, once I do my business, I can.
those are the factual dispute to be.
No, there is absolutely no factual dispute.
We'll see, just check it what is saying. Yes.
What a written note has been given without being serving a copy. That's most
It's all right, no problem. Now you get the time, now you ready. Yes.
The interim order to continue
Whatever.
interim order is not there
is there.
no
If it is there, it will continue. If it is not there, not there. Yes.
Item 2,
Yes, sir.
two my lord item 2 that 2459 that's it
No, so look at this, huh? 2, 3,
4.
4,
Item 4,
4 भी set है
4 which है?
4 5
हाँ,
7,
7.
नहीं नहीं 4 टा अलग है
4 टा?
sorry
Why are you not telling?
Wait, please, my lord.
Yes.
My lord, here under challenge is the cognizance order and the issuance of summons, my lord, wherein this petitioner has been arraigned in capacity of he being an ex-Tahsildar of Sambalpur Sadar, had entertained applications, 4 lease applications under the OGLS Act, my lords. The allegations are confined only to entertaining by this petitioner the OGLS applications for lease. If your lordship kindly comes to the FIR starting at page 25.
25.
25 minutes. 26, if your lordship sees, the petitioner has been arraigned as accused number 1.
Yeah.
Ex-Tahsildar Sadar Sambalpur.
Let us see the allegation.
Lordship, my lords. 27 is the recital, FIR recitals, my lord. Second paragraph.
You are Tiwari, Ajay Tiwari.
Ajay Tiwari, my lords. May I please?
Same
my
day,
lords?
basing on their application. Yes. 4 number of file applications.
Inquiry revealed, the second paragraph, my lords.
Yes. Yes.
Inquiry revealed that Shri Pashab Kesari Tripathi, while functioning as Inspector Vigilance Sambalpur Division Sambalpur in the year 2010, his wife Kalpana Tripathi, Shri Basudev Mishra, Shri Pratap Kesari Tripathi, brother, and Shri Alok Mishra filed 4 numbers of application along with relevant documents under OGLS house site lease in the office of Tahsildar Sadar Sambalpur on 27/9/2010. On the same day, basing on their applications, 4 numbers of file were instituted by Shri Ajay Tiwari, this petitioner, my lords,
Yes.
OS ex Tahsildar Sadar Sambalpur, as per Rule 11, Item number 7, Schedule 2 of the OGLS rules, while OGLS house site case numbers, these 4 case numbers, my lords, and sent the case records, very important, my lords, sent the case records to RI Sadar for submission of inquiry reports for verification and to ascertain the ROR position. On receipt of inquiry report from RI, the Tahsildar issued general proclamations, which is for objections, my lord, with a copy to SDA Sambalpur and GP concerned. After proclamation on 11/11/2010, Tahsildar mentioned in the note sheet that no objection was received within the stipulated period of 30 days. Thereafter, my lords, the Tahsildar goes to fix a premium. If your lordship sees,
Yes.
the premium of rupees 2,23,850 towards ground rent and cess for settlement.
Sanction has been taken.
sanction has been taken. my lords.
Thank you.
Thereafter, the last line, my lords, that paragraph, last but one line, my lords, on 2/2/2011, your lordship
Yes,
has it, my lords?
yes, yes.
On 2/2/2011, Sub-Collector Sadar Sambalpur recommended to the Collector Sambalpur for consideration of sanction of lease under the provision of OGLS rule. On perusal of the record, Deputy Collector Revenue Sambalpur returned the case record with an observation to resubmit the case record after compliance of objection made therein by letter dated so and so. Next paragraph, first line.
What is the ultimate order you pass?
The ultimate, my lord, I am not the approving authority, my lords, under the OGLS.
You entertain the application, sought for an inquiry report,
Yes.
and compile it and send it to collector.
Yes.
That's the
I am
allegation.
merely the recommending authority, my lords. The allegation solely is confined to this, that I, as Tahsildar, entertained those applications. I couldn't have refused on the face of it, my lord. That would be violation of the statute. I entertained it, made the RI to report an inquiry. On basis of the inquiry report, I recommended these lease cases for settlement to the sub-collector.
But how will you get out of the 120B? I don't know. What are the conspiracy? What are
That is the only allegation, my lord. Now,
against you? It is 120B.
if lordship kindly comes, the exact allegation, my lords.
Yes. Let me come to the charge sheet now.
No, my lord, page
What is
29. Page 29, last paragraph. Only that much I will
Yes,
pay
29, yes.
attention to.
Yes.
Last paragraph, my lords.
It is therefore.
No, my lords, 29. From the fact and circumstances, my lord.
Okay. From the facts.
Discussed above, it is evident that Sri Ajay Tiwari, OSX Tahsildar Sadar Sambalpur, criminally misconducted himself by misusing his official position, entertained the above applications, though he was well aware about the fact that all 4 applicants are not eligible to get the government land under the rule. He instituted 4 numbers of OGLS house site lease cases and took follow-up actions in their favor by adopting unfair means, violating the provisions of revenue law. Lords, in case there is a violation, there are provisions under the OGLS Act for cancellation of the lease or resumption of the lease.
Without obtaining any approval from the collector and Sambalpur,
No,
basing
that's
upon
not-
the order of or the subsequent. Yes.
There-
Yes, what you say?
Yes, it's
And
not-
see, a application under or rule 11,
OGLS.
sub rule, rule 7, sub rule 11, under the procedure has been filed. He could have rejected that.
No, he should not have rejected.
Then
Our case is, he in connivance with an inspector of vigilance, who is very close to him. Investigation is very close to him. He allowed.
close to him in the sense.
Because they have the relationship and they are they're going.
Where is
to
that?
their-
Where is
That is
that?
the investigation details. Our lordship can see.
Show me that.
What has happened in this case? In this case, an application filed by 4 persons who happens to be the relations of the
That
vigilance
is
inspector, and most of them are also public servant, and they are not eligible for to.
That's right. All these things are correct.
And-
But what is his role? This
Your lordship
And
can
that-
see the page 55 charge sheet.
55.
They apply
Yes.
last part.
And that shows the complicity of that inspector.
No.
But how do you know the inspector is close to this Tahsildar? How do you know that?
That is investigation set.
He is his subordinate.
As revealed, the lease application filed by the accused applicants.
Where are you reading? 55?
Last part.
Okay.
They are
Is it?
permanent resident of Bargarh and Subarnapur district, other than the Sambalpur district. All the declared there in annual commerce so and so only. All the accused applicants have not mentioned in their application as to whether he or she or any member of his or family own any land as required under column 8 of the lease application. That lease application has not filled properly.
Okay.
As for the annual income furnished by each applicant, they are not coming within the meaning of poor or homestelless person. While recommending the case for settlement of government land in favor of the accused applicant, Sri Tiwari has neither scrutinized the lease application form properly nor examined the eligibility criteria of the settled government land. No proper inquiry was conducted by him on material facts, basing upon which the lease of government land was granted. Thus, the recommendation for sanction of a lease have been made by him, ignoring the required mandatory and formality violating the provision of so and so. Then your lordship come to next same paragraph, last part.
Yes.
Rule 5b what says? Notwithstanding anything contained in rule 3, 5, so and so, settlement of a khasma land, natural land, lease out of a grammar so and so by use for homestead purpose. And as per clause 1, rule 5B of the schedule B, a person who is in possession of a gramo kantha, porama book, and abadi basti land in exercise of customary use of the so and so by way of a transfer to registered deed or conveyance so and so. This the document itself so it was not the land was belongs in the urban area and it was not it was abad basti hitwa darkar. Kintu then next page. However, their own representation to sub collector. Next page, your lordship.
Yes.
So,
Can you show me rule 11?
Lordship.
OGLS rule. Is there any precondition for inquiry or simply
Yes.
present in application?
they have same page lordship.
Have you reproduced anywhere?
Fourth page में लग सकते हैं हम देखेंगे उसमें लग
Rule 11
Let's
of schedule 2 of
page 5.
rule 11 of the rules में I place में
read it.
authorities competent to dispose settlement. Disposal of applications for settlement of lands for various purposes shall be made by authorities specified in Schedule 2 up to the extent mentioned therein. All other cases for settlement of land shall be referred to government for orders.
Yes. So inquiry is prerequisite. Where is that? Where is that? Where will I get that? If prerequisite that he has not done, then it will maybe 120.
Inquiry is done by the RI. I am not a field officer to do the inquiry.
Yes.
On the he is recommending an application which has not been filled up properly.
Where is that application?
It is not so well.
That justice said that the application is not filled up properly,
No,
whether
no.
it's a land or no land.
That is reading between the lines, my lord. If your lordships may permit me, all the allegation says is that one particular column, that is column 8, so to specify with regard to the income, has been left vacant.
The problem is how can I decipher your role attributable to you? Because see, it is 120B. Whether you had conspired with the other co-accused, the beneficiary.
There is nothing to that effect, my lords.
So that how will I decipher your role at this stage? That's the question. Unless you make out the case, your case is completely separately, it can be tested. And unless you say that the inquiry is not a precondition, it's a formal application. It came to me and I accepted the application and forwarded it.
I have forwarded it, my lords.
If that is the case on the rule, you have to show me.
Lordship.
Show me the rule. Otherwise, your complexity has to be tested there in the trial only. At this stage, in 482 stage, at this stage, I can't. At the cognizant stage, you argue all this point by moving a separate application. Let the trial court get the advantage of an order.
No, that will be
separate order.
Well, it's all I'm saying is in exercise of being a quasi-judicial officers under the Act and rules, I have merely forwarded these applications.
After reading page 55,
Lordship.
How will you question a cognizance order? Answer this. Page 55. Read page 55, which was read out to.
Yes.
Last paragraph of this.
As revealed from the lease applications filed, they are permanent residents other than Sambalpur districts. All have declared their annual income as 2,50,000 only. All the accused applicants have not mentioned in their applications as to whether they have not mentioned, my lords.
So therefore, was it not necessary on your part? Anybody can move an application, you entertain and start proceeding.
That's
the question. So therefore, I think according to me, the cognizance is correctly taken. And it has to be tested. You have to argue at detail at the stage of framing of charge. Move an application. I'll give that. I'll give that liberty to you. Move a separate application for discharge, and the trial court should deal with it and pass an order.
I have my difficulties there, my lord. The 482 scope is much wider than the
482 scope. Testing cognizance order
Lordship
is lesser than the 482 court or a revisional court testing a rejection of application under 220.
Lordship, that was the position, my lords, until last week, my lords.
So fine.
Decision of the Supreme
show
Court.
me.
I'll get that, my lords. The question has come.
These things senior advocate do generally. When an inconvenient question is put, then
No, my lords,
ask for adjournment.
I
You
have
this
library
with your all preparation.
library
This license is not there with you.
I can
Okay, let him come with that.
Citations writing.
You come with that.
Yes.
But you have a very difficult case. I don't think you can.
No, it's there.
If you can satisfy me recent
Yes, sir.
judgment, if you are showing,
Thereafter, later, what has happened? Even the
then if that is the case, in these kind of cases, if the 482 court start entertaining and cognizance stays, then virtually we are conducting trial, reading every document and everything and pass a judgment of acquittal.
No, there is no
And there
material.
is see, the prima facie case is made out. Then there is a system of moving an application for discharge. You can very well say that 13(1), 2 and 1 is not made out. 120B is not made out. You can make out a case. For that, you have to move an application under 227.
Well, there is no loss, my lord, that is there.
All this thing has to be gone into.
Lordship.
Gone into. You can't pick up the selected paper from the charge sheet and file it and say that no, cognizance is not there.
In fact, what has happened after that, my lords, that collector has conducted an inquiry. The leases have been cancelled and resumed.
Looking into your persuasive capacity, I am sure that your 227 application will get better audience.
No.
I'll give that observation go.
No, my lords, I will make my case here, my lords, on prima facie.
All right. Okay. Next.
For hearing, let it come.
Yes.
This was for admission.
Yes, I'll adjust. Yes. Next.
Item 5. I will share. Detail explanation.
5. At 2 o'clock, all these batch matters.
But my handicapness is, my lord, my luncheon is depending upon some judgment. Let me get a copy.
He is not yet started. I don't know.
Saying on the other day, there is some other judgment. What I am relying upon.
No, he is relying upon couple of judgments. Mr. Dhawal is also
yes,
arguing.
I have my own judgments, my lord. If my luncheon has some other judgment, I will ask for help.
So that I can go. At the end of the board, I'll take it up.
There are so many points of law that is to be adjudicated.
There are so many points of law. Only one.
नहीं अपन जजमेंट जदि किछि दोउछन टिके देले हमु तो पढी के आसे में सुविधा हो टिके जजमेंट गुडा कोन जो दोउछन देले टिके पढी के आसे
preparing for adjournment, give the judgments.
दे देले नहीं अपन जो
Give the citation.
citation देले बेटर हो मु आगे एक्चुअली रे
Citation, give the citation in writing so that he can get it.
फाइल लिखो
Please and cite.
yes some other day or today man
Let us see today how we can proceed. It may happen today, may not happen today. I don't know.
I have a special bench at 2 p.m. so I know.
Send someone.
Any case
नहीं सेमिति के मौके से मुझे कैसे सेट करने
You send someone.
बाय बाय
7.
Yes. Yes.
There is an accident. And one person was died. Last time for this person was identification now is not it is read that the proceeding should be quashed.
It's not an accused.
This for plastic plastic.
So I pass it over. We can dispose it up. Yes.
Maybe.
The matter arising out of the complaint case and earlier was page 30 for job that will by both parties.
Yes.
And on 7th, another applicant filed and shown the Supreme Commissioner, same as filed on 7th December. And the counsel for the complainant name is also in there. And the ordinance have been taken 323, 294, 420, 506, which is SCT. What do you want?
Come here. No. It is very lawyer after. Yes. Is there. Who is the informant?
The council has already appeared on 7th.
No, here he has to come here.
Because of the universe of
Other than simply. We going to case yes. Next. 10. Yes. Yes, sir.
Order on the pending is a cognizance taking order. The petitioner is a housewife. She has been arraigned as co-accused in the vigilance case, GA case. In the GA case, she has been made a co-accused and has been arraigned on the section 109 of the IPC.
Yes, so me, yes, any
There are
separate
Yes.
defense?
Page 5, your lordship, I kindly say.
What are the properties? in your
Page
name?
5, page 5.
Yes,
Page 5,
your housewife,
housewife.
having no income.
No. Well, 3,40,663 टका joint account रे अछि, joint account with the
That's
husband.
not. Yes, I think he is covered by that judgment.
And then I have to take it.
Your lordship judgment
He's
where?
covered. If he's covered, why I am waiting?
Okay, first time I see. You know, after the
Because he is a housewife.
housewife.
She doesn't have any income.
No defense also.
The no defense, then she is covered. Why unnecessarily keep it?
Okay,
Monday, Tuesday. I'll dispose it up.
Sonalata versus Son.
Authority. Notice. If you notice, Mr. Marana accept notice. Leave the matter.
Stay.
Stay for the proceedings.
State adjournment application.
Thank you. Stay thao.
Vigilance case is.
केबे आसीबे केबे न आसीबे
18th, otherwise stay is not required. See, you simply tell me it's covered, then I'll pass that order.
I am satisfied. What I have to take instruction on that.
नहीं आगे स्टे नथिले असुविधा ही पारे.
State not possible.
Application for adjournment. If such application is same shall be continued. Yes, application. But don't take adjournment. I want to dispose it.
I will not take
You
adjournment.
are directly covered by that.
I have come up with your lordship judgment.
You are directly covered. But he without accepting notice, without seeking
Let
instruction.
him do that. But I am aware of the judgment rendered by your lordship.
Yes.
From 12.
Good. Yes.
Look, actually, my learned senior is
Mr. Patra, you have to wait till 2 o'clock.
My lord, I will do it.
Because the batch matter is there, all the laws will be coming at 2 o'clock. Okay.
Apart from that, my lord, some it's also okay. I will.
If that issue is decided, then if you are covered, it's covered. You are not covered, then the rest of the issue will decide. Yes.
My
Next. 13.
My lord, sir, NDPS case was registered by the present petitioner, my lord, while he was working as IIC Judicial. Thereafter, my lord, sir,
You are the inspector.
I was the inspector in charge.
Yes.
Thereafter, my lords, in the news channel, there was a audio clip that I have demanded 3 lakhs bribe for releasing the vehicle which was involved in this case. Now, my lords, thereafter, this investigation was transferred to crime branch. Crime branch apprehended me and I was thereafter subsequently released on bail. Now, my lords, they have filed charge sheet against me. My lords, also subsequently a PC Act case was initiated by the Vigilance Department and they did not find any DA, my lords. So that was dropped. That case was not registered. Only a raid was done at my house, but no case was registered since no DA was found. Thereafter, my lords, your lordships will see at page 23, the crime branch has entangled me under section 21B of the NDPS Act and 29(1) of the NDPS, 29 subsection 1 of the NDPS Act, which is for carrying the narcotic substance, my lords. How is this offense made out against me, my lords?
You are the inspector.
1B of 201 is purely better than this law. The present prisoner, while working in the IAC in the Judicial police station, has demanded rupees of 5,000 to the accused prisoner.
That is DA case.
But
that is the corruption case, whatever. How NDPS in this case?
What happened in this case, initially the FIR is registered by the present prisoner while he was working in IAC. And then the matter was referred to the crime branch. Crime branch, after due inquiry, your option has filed charge sheet against present prisoner or state. 21B or 29 subclause 1 NPS Act.
No, because you try to prosecute him for corruption, and there you fail. Now you registered this case.
Can you just tell 132 charge sheet?
132?
32 and the 31 year old.
Yes.
31 year old can
Yes. 31.
Yes, sir. Second paragraph.
Yes.
There was an allegation of demand of rupees 5 lakh by Dhaneshwar Shah, present petitioner, Lordship, ex-IAS Judicial Police Station. And accordingly, he has taken 2 lakhs from the accused petitioner by an advocate, your Lordship. The advocate is a middleman.
It's all right, you prosecute him for corruption.
That's right, your Lordship. But
You do whatever, he has demanded money. How he is involved in NDPS?
120B is clearly matter, your Lordship.
120B for what? NDPS? For demanding money. From an accused of NDPS, he is asking money. Therefore, he is also involved in NDPS. What is this?
Demanded.
What kind of cases you are making? He might have done whatever. You prosecute him of corruption because he has demanded money from an accused in NDPS case.
Yes, sure.
He had taken 2 lakh rupees.
Yes.
Okay, he had taken 2. Therefore, he is liable for NDPS under 120B.
This case is another incident against present petitioner. That's
That
right, your
you do whatever you want.
That effect, I have no instruction whether the vigilance case is pending or ended with
Merely he has taken money from the accused in NDPS case. He is also an accused in NDPS case under 120B.
120B and 201 is
Very nice story you have made out. Issue notice, so accept notice. In the meantime, further proceedings take.
Grateful.
For the petitioner.
Grateful.
You don't have a case. 120B. How can you make 120B against him? Anyway, if any other material is there, you tell me so that we will examine. Okay.
Grateful.
Yes.
May I please your lordship? My lord, in this case, the petitioner has challenged for quashing of proceeding. They filed this petition for quashing of the proceeding. Due to civil dispute, the informant has lodged FIR against the present petitioner and subsequently investigation has been made and charge sheet has been submitted.
Yes.
Both accused person and the informant belongs to one village, and subsequently they have made a compromise in between them, and one affidavit has been filed by the informant. That is running page 42, annexure 3.
My lord, I am appearing on behalf of the informant, my lord.
Yes.
7 and other 480, 380, 457, 436, Lord. So the injury part is mentioned, but the injury is also page 41. And the injury is simple. Last injury, Lord, that is page 41 and injury is simple, Lord.
They have settled their dispute.
But another 42 is the page 42 is the settlement affidavit filed by the informant. That matter is settled.
The parties have to be present.
Here, present, madam.
Yes.
My lord, present.
Who is what about
age of the informant is 17 years and petition age of the petitioner of the informant is 17 years and petition age of the petitioner is 18 years. That's allegation. There is 354C and 67, 67B and 67E of ITI, informant technology. Now they have been, matter has been settled. They have filed this joint affidavit as it flag B.
I am appearing for the informant.
how will you get over the judgment?
No, it is not a case of rape, Lordship. It's not a case of rape. It is only between misunderstanding.
Let us see the see the allegation. Let us see the
Lordship. The page 10 is the affair. Page 10.
Only the allegation is he has taken some photograph and circulating it. There is
no sexual assault or anything.
Where is the girl?
Coming, Lordship. Let it pass.
But
making pass.
You distinguish that they were now they are
yes, they are both are coming.
Both are coming.
And he's not in custody.
No, Lord. They have filed joint affidavit and
he has been absconding. So now how he is not taken into custody? How the accused is not taken into custody? I am asking.
No, he has not granted bail. He was not granted bail.
He is absconding.
Lordship, he is absconding.
What is the stage of the investigation?
Charge sheet has not yet been filed, Lordship.
Then it has to be, a notice has to be issued to, he has to get the issue notice, listed on next Friday. Let us see. Allegations are not serious, but whether, what kind of photographs and all that is.
Yes. Can he be protected in the meanwhile? The petitioner.
What do you say? He young boy, 18 years. Life
Is the college going well? Is the college going student, Lordship? The career will be spoiled.
Small children are, they don't understand what they are doing. Why to spoil their life?
Yes, ma'am.
Under counsel for the petitioner, the present petition is filed for question to the apart number so elevation of the petitioner is so on advance notice, counsel ended a period for the victim. Both the counsel conjointly submits that the parties have settled their dispute and have also filed affidavit to that effect. Issue notice to the state, with the notice, we see matter on Friday, and in the meantime, no proceedings have been taken.
16.
The petitioner is an 18-year-old boy, and where the victim is also of the same. No proceedings. 16. Yes, sir.
Lord. I'm for the complainant.
Yes, sir.
Learned Sessions Judge Kendrapada wide order dated 7/11/24 rejected the application filed by the petitioner for grant of exemption from deposit of 20% of the compensation awarded by the learned SDJM Kendrapada in 1CC case number 238.
Yes, tell me. 20%. Yes. 20% deposit.
Lordship. My
20% deposit is 148.
Yes.
After conviction.
Yes. Suspension. That is
Learned court below did not take into account the exceptional circumstance. Why? The levy of
generally
20%
the
should
exceptional
be paid.
circumstances theory is available at the stage of 143, not at the stage of 148, because you have been convicted. There is a judicial finding against you.
The case of Jambu Bhandari is quite clear.
Pay 10% and move up.
Lordship, 10% is like Lordship, the check is not encashed by the named beneficiary. There are two names in the check. In that context, Lordship, I would like to take your Lordship's attention to Annexure 4. Annexure 4. Sorry, Lordship, Annexure 5. That is at page 27.
I remember this.
Lordship, there are two different names.
I beg your Lordship's pardon at the outset. But this is a finding of
issue to
I come in to this is a finding in fact and has been dealt with succinctly by the trial court. Apart from that, the order impugned is passed under 140 as your Lordship has already heard.
Show me the complaint copy. That's what I asked for. Show me the complaint.
Already filed.
Where is that? I urgent the matter to see the complaint copy.
Yes. I filed the certified copy. That we are filing. 140 is your Lordship after conviction.
No, that's right. Generally,
no more
in general principle, you are correct. But here is a case where the check was issued by one Suryo Kasinath.
That has been dealt with.
And you are prosecuting Kasinath.
No, that has been dealt with.
And conviction to Kasinath and Suryo Kasinath is here.
My humble side distorted that. As developed in appeal.
Okay. Let us see the complaint. Where is the complaint? So
we have filed the document.
It's not there.
Yes,
it's not there.
If your Lordship bold, it has come. I have filed it.
No, it's not there. Can you please?
If your Lordship permits, can I please call? From my
That is come order in the court.
And you have prosecuted Kasinath Sahu.
Yes, your Lordship.
I have prosecuted Kasinath. The check is issued by the Kasinath Sahu.
No, just see the check.
That is subsequently. That for the learned trial court has hold that it has subsequently interpolated. Your paragraph and judgment is very clear.
Just see the page 27. page 27 is Surya Kasinath Sahu.
Yes.
Kasinath. Your lordship, the certified copy which the check I filed in the complaint petition, your lordship can see.
Okay, that
The check your lordship is taking note of, that is
Annexus 6.
that is subsequently certified copy, which I filed should be taken into account.
Lordship, I may be pardoned to interrupt this one more
minute.
pertinent point.
1 minute, sir. Let me understand the fact. Wait.
What is my certified copy does check here?
No. Give me that. Okay. This was the check.
Yes. Complaint petition.
Kasinath.
I learned.
This is check.
Lordship, it's not within my knowledge. These are the copies. But Lordship,
He's got a certificate copy. You have filed some document here as Annexure 5. Here it is written Surya Kasinath.
Yes.
Surya is interpolated because there is a space here. Surya is written. Why should I go into all this after conviction?
Lordship, one more pertinent.
I thought the two person.
Lordship may consider one more pertinent point.
Yes.
Well, Lordship, 130, section 138, clause A says that it is applicable to only valid checks. This check was not valid.
There is a judicial finding that is a very valid check. Now it is interpolation. Surya is written there. What to do?
Lordship, page 26. There are a couple of grounds which your Lordship may very. Page 26.
Yes.
Annexure 4.
Yes.
This is the directive of the RBI, which states that non-CTS checks are only valid till 31st July. And in a recent judgment delivered by the Honorable Allahabad High Court on June 5, in the case of Archana Singh Gautam versus State of UP, which is reported in 24 AHC, it was reported that the checks that are invalid do not attract the liability under section 138.
Give that certificate copy. Yes, sir.
Lordship, the check is of the year 2013.
Yes.
The check is of the year 2013.
Yes.
It has been presented in the year 2015.
Yes.
But the RBI has clearly stated that these checks are to be treated as invalid, and the penalty date of deadline per annexure 4 at page 26. The RBI will review the deadline in June 2013. Checks issuing banks shall make all efforts to withdraw the non-CTS 2000 standard checks in circulation before the extended timeline of 31st July 2013 by creating awareness among the customers. So, Lordship, these checks had a penalty made date of usage till 2013 only. July 2013 is the deadline. How could a 138 check be maintained in respect of a check that was not in circulation? The check is the check apparently is of the year 2013. So it becomes an invalid check altogether.
So why have you issued then? Your signature is there. All these
Lordship,
things.
it's not even my signature. I've taken that.
Those
step.
things. See, there is judicial finding. There is a conviction now.
Yes.
How can I go into all these things? Am I deciding the appeal today?
Protects me. I can sufficient.
You tell me, am I deciding the appeal today?
Lordship,
It is a matter of 20% deposit. That's the statutory command.
For non-deposit,
I will have to see two things. One is the prima facie case is there or not, and financial constraint.
Lordship, the prima facie case is.
So therefore, what I generally do is I reduce it to 10%. You deposit 10% and go and argue.
Lordship,
that's the only thing I can do it. And you get 50%.
Lordship is kind enough to reduce 10%.
10% I'm doing it because unnecessary, the matters are unnecessary pending here. Pay 10%, go and do it.
One question arises. How can 138 be maintainable in respect? Lordship, Proviso 8 clearly states. Respect of.
See, if I
this is the circumstance.
Why try to appreciate? While deciding this application, if I say that it was not maintainable, I am entering into the arena for the appeal.
Lordship,
I am doubting the conviction order in a 482 proceeding while entertaining 20%. How can I give that finding here?
Lordship, the Jimbo Banerjee case only sets out the exceptions. The exception is that how can
I have seen the exception. I was impressed by the point which you have taken. That is Surya Kasinath. But now he has given the certificate copy. It is Kasinath. It is interpolated. And therefore, there is a finding against you by the trial court that is.
Lordship, even the
I can't help it.
that will lordship in 482.
I can't. And the circumstances which you are citing, it goes against you. You the finding is you are interpolated.
Lordship, how can
Not it is 138 case. It is something else beyond that.
now how can 138 cognizance what 138 be maintainable if the check is invalid at all? That is clause.
I can't delve upon the issue of maintainability after conviction. That is the appellate court's jurisdiction. Appellate court will
It's
decide.
about the exceptional circumstance.
Anyway, there is no.
Considering my circumstances.
Yes, there is no further this thing. If you want 10%, I'll do it, or otherwise I'll pass an order. Retail order. Retail order may create problem for you unnecessary. Don't do that. I deposit 10%. What 7 lakhs? 10% you deposit, and I'll tell that the appeal will be expedited.
Lordship, substantive justice will be if it can be directed that the appeal be disposed of within a certain
That I'll do. That I'll do. That I'll do.
Lordship, in that case,
By
saddling me with 10% won't. I mean,
You can't have both. You can't have both. Either 20%.
Lordship,
the fabric of the amendment.
Okay, I'll pass the order. I'll pass the order. Yes, next.
Obligatory, diplomatic.
I'll pass the order. Yes, next.
So 70.
What they do?
the NI Act matter or say the complaint petition will be dismissed.
In fact, cognizance has been taken in a complaint case.
Yes.
On the date of hearing, while the petitioner was coming to the court for attending the court for evidence, she met with an accident. So an application was filed for time that has been rejected, and now the complaint petition has been dismissed.
That is sufficient. Cognizance is taken. When it is dismissed?
Page 18, Annexure 4, my lord.
18. Yes. You are agreed by the issue. Advocate for both the parties.
Time petition was rejected.
The petition paying for time for bringing the ground to Why have you not moved application there?
I had moved the application. Time petition was rejected. Time petition was rejected.
No, after dismissal, you could have moved the application.
No, petition पर नहीं.
Anyway,
restoration provision.
What was the check amount? Check amount.
Check amount that is there in the complaint petition I have filed, my lord.
You tell me.
Check amount is 2,50,000.
Right. Petitioner is agreed by the order dated 23/9/2024, whereby his complaint under section 138 NI8 filed against the opposite party has been dismissed for non-prosecution. The impugn order for ready reference, the impugn order is reproduced. Prototype it has 18. Mr. Vishal and counsel for the petitioner submits that the complaint under section 138 NI Act against the opposite party was filed on 21/9/2022. The learned SDJM Kamakshanagar by order dated 4/4/2023 had taken cognizance of the offences punishable under section 420 and all.
420 and all.
Punishable
Cognizance has been taken.
Only there is no
468, 506.
There is no 138 then.
138 9. Cognizance has been taken under section 420, 468, 506.
Oh, there is no 138.
138 cognizance nahi na.
It is not a 138.
No.
And 420. 138 cognizance is not taken.
138 cognizance nahi na.
Then don't write so and so. Taken cognizance for offences punishable under section 420, 468, 506, 294 IPC. However, no cognizance under 148 has been taken. Subsequent thereto, due to the subsequent thereto on 23/9/2024, the petitioner appears to have moved an application seeking adjournment, which was turned down, and the complaint was dismissed for non-prosecution. He agreed by the same order. issue notice to opposite party, written evidence. Had it been 138, I would have allowed right now. It is 420 and all, so therefore in notice only. Yes,
it's not that.
138, I would have done it immediately. But I thought it is 138, I started dictating. Yes.
Another matter, my lord, pass over which is
Pass over
item number
which?
10.
No, pass over which?
Where is a small?
Whatever, pass over, we have to wait. Yes, next.
After recess.
Yes.
May I please, your lordship? I am in VC item number 18, your lordship.
Yes, sir.
My lord, the application filed by the petitioner before the London JMFC for a joint trial, my lord. The fact is that, my lord, annexure 1, your lordship kindly have a glance. The wife of the petitioner was committed suicide and one affair was lost on the same day. Your lordship kindly have a glance on the annexure 3. Annexure 3 running page 30.
Yes.
Your lordship got it, and running page 30, your lordship.
Annexure 3.
Annexure 3 running page 30, your lordship.
30, yes.
Smell, on the same day, the in-laws member had assaulted the petitioner and his father. My lord, after the affair was not registered, after the direction of this honorable court in CRLMP number 2598 of 2022, the affair was registered against the informant group, my lord. After that, the case was committed to the London JMFC Dhamnagar, where the present petitioner has filed a petition under section 323 CRPC for commitment of the case record to the London DJ Bhadrak for a joint trial, my lord. The application is still pending, my lord. And now the other cases against which was lost against the petitioner is still going on, my lord. For which the lordship may kindly stay the other cases, still stay the cases before the London trial before the London DJ Bhadrak till final outcome of the petition filed before the London JMFC Dhamnagar, lordship.
First, you have to justify whether it should be tried together or not. Then only the question of stay comes.
Your lordship, my lord.
Why should it be? Why should it be taken? What is the impugned order? You show me.
The impugned order is not there, my lord. Your lordship, the annexure 4 is still pending for filing.
Have you moved the trial court?
Yes, your lordship.
Then you go and ask there. How can I? Application is pending. There is no order. I will interfere.
Because, my lord, the another case is still going on, my lord.
You have to move that court only for the purpose of interim.
Yes, your lordship. I have filed a petition. This is annexure 4 running page 46, your lordship.
Yes.
In the year 2024, my lord. Annexure
I'll
4
just direct the trial court to decide the application. Yes, I'll dispose it. Right.
Obliged to lordship.
Petitioner is agreed by the non-disposal of his application moved under section 323 CRPC CRPC before the before JMFC Dhamnagar in GR case number 2023. The petitioner contended that petitioner he is the informant in Dhamnagar PS case number 12 or 23 corresponding to GR case number 23 of 23 for alleged commission of offences. And simultaneously, next subpara, simultaneously he is also an accused in Dhamnagar PS case number 101 of 2020 along with other co-accused person for alleged offences punishable under section so and so. He has moved the application for joint trial of both the cases. The said application has not yet been decided. Therefore, he has approached this court seeking an interim direction that unless the application moved by him under section 323 CRPC is disposed of, the trial of ST case number 58 of 2020 arising out of which case is this?
ST case number 58 arising out of Dhamnagar case number 101 of
the first 23 shall be directed to the state. So I am not inclined to entertain this petition in view of the fact that the application under section 323 CRPC moved by the petitioner is still pending before the court. However, I am of the considered opinion that the learned JMFC Dhamnagar shall do well to see that the application moved by the petitioner on 4/1/2024, which is pending before it shall be considered as expeditiously as possible, preferably within a period of 15 days hence. Yes. 15 days.
Yes.
Let the application, let him decide. Yes. With this observation. Yes, next.
May I please, madam?
19.
My lord, in this case, I have challenged the order dated 21/11/2024, my lord, passed by the Law and Court rejecting my application, and where I have prayed to simply give a direction to the police to seize a machine which is in illegal possession of the accused. I am the bona fide owner of the property. My lord,
How can the High Court give direction?
My lord,
do this,
my lord,
do that?
My lord, my only submission is, my lord, the property belongs to me. I am the bona fide owner.
Whatever, can the High Court in a 482 proceeding?
My lord, what happened?
Seize something?
My lord, the valuation of the property is about 60 lakhs, and now he has engaged that machine on a hire basis and earning 4 lakhs per month.
What is the prayer you have asked?
My lord, my simply prayer is that the machine should be seized. As far as the custody is concerned, that will be decided by the Law and Court.
Why to answer one thing?
My lord, that I know. I am aware of the position, my lord. Then, but I am helpless, my lord. My lord, the police is not taking any steps.
And then I will only say that whatever grievance you have, the IO has to address it.
Yes,
That's all.
Filed only last days of affair.
I know, I'm saying.
My lord,
Investigation is going on now.
my lord, that is the reason, my lord.
I petition
My lord.
seeking a certain exploring the following relief in the present petition. The relief sought by the petitioner cannot be obtained as the investigation of the case is still going on. The court, while exercising jurisdiction under 482 CRPC, is forbidden to give specific direction to the investigating agency for seizure of any property, etc. Therefore, I'm not inclined to entertain this petition at this stage. However, petitioner is granted liberty to apprise the investigating officer regarding his grievances, and it is expected that the investigating officer shall do well to see that the grievances of the petitioner will be attended in accordance with law.
My lord, that has also been the observation of the learning court below, that the court, however, acknowledges the petitioner's right. I have got a right because I am the bona fide owner, my lord.
The trial court is correct, and I am
that's true, my lord. I just can't dispute that order.
Because see, we can't give direction, so therefore we just find out to justify something. We find
out a simple way.
That's the only thing. Instead of sending someone without any order, just give some observation.
It may help me.
Yes.
20.
This case will count this for questionment of entire proceeding. Civil dispute. Notice
FIR. I'll issue notice. Huh?
Case notice.
Yes.
Yes, Lordship, it's
Issue notice to
the FIR is nothing but a
party.
counter.
File the requisites. Opposite
Lord.
part number 2, Mr. Mahan.
Lordship, IA, there's an interim application.
I need notice on interim application of. Yes. Next.
21.
21, my lord. My lord, one FR was filed under that page 8, annexure 1, 419 and 420. Thereafter, charge sheet was submitted, and the court below issued me notice under annexure 2 at page 14 that why the final form shall not be accepted. My lord, I have filed a protest petition under annexure 3 that is registered at 1cc case number 3425. My lord, I won't only pray let it be expedited. Nothing.
This will be you have a right to file protest petition.
Fine. I only want that your lordship may direct the court below to expedite the matter. This much as.
I don't know how many witness pre-summoning witness you are examining.
No, two witnesses only, the complainant and one more witness. Just if you lordship.
I'll just give observation that it should be done as expedition.
Yes, man, that will do.
Petitioner is the informant in FIR number so and so. After investigation, the closure report has been filed by the police by
My lord, Annex 2.
Annexer
2, page 14. Notice was issued to me that why this cannot be accepted.
When the closure report was filed, you don't
My lord,
closure report was filed by the police. Subsequent thereto, by the notice dated, what is the notice dated? Date we need.
my lord, that is 3/5/24.
You are called to appear on that.
Yes, but notice
Subsequent
was-
thereto, notice was issued by SDGM Bhubaneswar under section 173(2) bracket Roman 2 of CRPC to the petitioner, calling upon him to explain as to why the final form filed by the police shall not be accepted. In response to the said notice issued by the SDGM Bhubaneswar, the present petitioner, while his application dated 1/5/2024, has filed the protest petition, which has been registered as ICC case number
3425
34
arising out of city number 461 of 20.
arising out of city number 461 of 2020. Mr. Bose, counsel for the petitioner, submits that a direction may be issued to the trial court to expedite the disposal of the protest petition. Protest petition. Needless to say that speedy, free, fair, and speedy justice being is a constitutional mandate. Therefore, the trial court is expected to do and to see that the protest petition is disposed of as expeditiously as possible. It is made clear that petitioners shall not seek any adjournment before the court on any pretext.
Man.
Yes.
22, may I please? This is a case where I have challenged the cognizance order on the ground that matter has been settled between both the parties, my lord. Offense on section 363, 366, 371, 76(1) and 6 POCSO. The occurrence took place in the year 2018. And in the meantime, they have married and have been blessed with a child. And my learned friend who is appearing for the victim. And though the informant here is the mother of the victim, so can it be taken? So because her appearance is also very much essential. My learned friend is appearing.
But the same problem, now there is a judgment, Supreme Court judgment, that
My
in
lord.
POCSO cases you can't interfere.
My lord, because fact remains they have already been blessed, leading
That's
marital
right.
life.
How can I ignore the Supreme Court judgment?
Yes, yes.
I'll just issue notice, you just verify it. I'll just simply issue notice. I can't help it. Issue notice to the informant and victim, lease the matter. I can't do it. Because that is you read that judgment.
My lord.
Ramji Lal or something.
Ramji Lal.
Otherwise, you are covered by my judgment.
Yes, yes, yes.
Rosalind.
So many judgments, my lords, are passed.
Rosalind judgment you are covered.
So many judgments.
And I have given the guidelines also.
Yes,
in
yes.
which cases it can be passed. But after this judgment, there is a problem.
My lord.
Let's examine how can you distribute this case.
My lord, till then, at least the proceeding matter. Because this is the situation. Till then.
You are on bail.
Yes, yes, yes. I am on bail.
Bail, then nothing is good.
My lord,
better. No. It's better that I'll tell you. In a couple of cases, what I did is I didn't allow the 482 petitions. Rather, I allow 311 petitions. So that the witness in those cases where the victim had already deposed against the boy, thereafter the compromise. I said move 311 applications and take him.
Another way.
Another way. Rather, it is better that the girl should go to the court and make a statement. You will be acquitted. Staying the proceeding is detrimental to you. Why are you asking for stay? Rather, you take the girl and she should be examined. If she will not support the prosecution, you will be acquitted.
Yes.
Don't ask for stay. Rather, you cooperate. Let the notice be issued. Shall I record that you have? I'll do one thing.
311.
I'll dispose of saying that I'll not interfere in view of Ramji.
Yes.
but I'll direct the trial court to examine the girl.
Yes, yes, yes.
And the mother, informant as so and so, as first witness.
Yes.
If they will not support you, you out.
But he examined perhaps they have been examined to minds. So they have been examined.
Just see, I pass it over. Ask me. Ask and tell me.
If
They have already examined and supported the prosecution, then you have to move application 311.
Yes. I have.
If they are not examined, then I'll give that direction.
No, they have been examined.
They have already been examined. Kindly glance to page 24, answer 4, 164 check on the victim, exhibit is in mark.
All right. 311. You move 311.
Let notice be issued.
I have issued notice. Move 311. Yes.
23.
Let's we seek one Passover. Mr. Jacobonso has been appointed and he's on his legs.
Yes. Yes. Yes, sir. Yes.
Let's see the impugned order of cognizance is under challenge.
Yes.
See the proceeding before the learned court below is under section 138 of NI Act, Lordship. The check was issued by the company, but the company has not been added as an accused.
I issue notice, issue notice to opposite party. Where is the, show me the complaint, check is issued by company.
Lordship, complaint is at page number 10, my lord, annex 1.
Show me that.
Page 10, annex 1.
Where is the check? Where is the check? Check was issued in whose name? Show me the check. You are the builder.
Yes, I am the managing director of the company. 2 checks are there, my lord.
Jivan Sathi, huh?
Yes, ma'am.
Jivan Sathi. And for the petitioner submits that the petitioner is being prosecuted as in the individual capacity, although managing director.
Yes, ma'am.
You have been implemented as a managing director. Company is not there.
Yes, my lord.
Petitioner is being prosecuted in the capacity of managing director of Messrs. Jivan Sathi Service Private Limited for the alleged offences under section 138. The check was issued by the present petitioner on behalf of a company. Although the check was issued on behalf of by the petitioner on behalf of the company, however, without impleading the petitioner, arraying the petitioner, arraying the company as the accused, the petitioner felicitator is being prosecuted. Even the counsel for the petitioner also submits that even the statutory notice was not issued to the company. I have perused the notice under section 138 NIF issued by the opposite party and the copy of the complaint. Copy of the complaint. Indeed, the petitioner, indeed, the opposite party has not arrayed the company as an accused. Issue notice to opposite party written in so and so. In the meantime, proceeding before the trial court in 1 CC case number 235 of 2024 is stayed. I'll just come. Okay.
That reflects.
ये copy bit, soft copy there, no? Hard copy is there. No. Hard copy is not there.
It's can be put.
I mean, pardon, my lord. Item 7, that was passed over, that will become after vacation, my lord. I have to file some document. Item 7.
7, oh, yes, adjourn court, yes.
Yes.
Continue.
And lordship, but after launch, there is a big matter.
And in fact, the mentioning is.
No, not mention, let's say. After launch, lordship, but there is a big matter, but perhaps it is. After launch, the vigilance matter is there. My matter 75. After launch, I have some.
Big matters are bound to be adjourned. You know that. Wait, I'll take up.
In particular, Friday, lordship.
Let us see. I think I can reach there.
75.
I'll reach there.
Then lordship, my if it will not
Yes,
reach,
yes,
my
yes.
associate there, lordship.
Yes,
I
no
prefer a time, lordship.
Yes.
That's full, lordship.
Item 26.
Yes.
Order 13/2/24.
25 urgent.
22? Urgent, yes.
Lord, this is that matter, my lord's lordship asks Mr. That he was holding a post where the post was abused. Thereafter, my lord,
Yes. He understood now. Therefore, he has taken adjournment.
if it comes within the vacation, prior to vacation, my lords, then can be
Let's
disposed
see
of.
how we can adjust.
Can be disposed of, my lords.
It can be disposed of. Why no?
Three adjournments, a lot of times to
You can give.
2 minutes, my lord.
Yes. Yes.
Lordship, enrolled data 13/2/24 lordship.
Yes, and bail?
18/2/15 lordship.
500 each.
Lordship, one fair lordship, in fair court, my bail date is in my enrolled date is wrong.
13/2, na?
36.
13/2, it is written rightly. 13/2/2024.
Lordship.
Rightly, handwriting. Yes. Yes.
Earlier they were on bail, my lord, posted for trial due to absent, my lord, NBW 1st March 24.
Yes. 500. 500 each.
Obliged.
Yes.
3 person.
Yes.
28.
Lordship, 28. Order dated 20 September 2024 lordship. It was only
Sorry?
28.
20th September. 24. And bail?
Bail is on lordship.
5th March. 2020. 5th March.
5th March 2020. Yes. 500. Yes.
29.
29. Made peaceful lordship. Lordship, I'm on Twitter. I went for doing the auditing. Since I found the gross irregularity in that particular company on the very next day, my lord. Lordship, may kindly see page 12.
What are you seeking?
I'm seeking for passing the NBW money.
I'll cause it. You appear 500. Yes. Give 500.
My lord, Belchometer, my lord, item 30.
30? Yes.
Belchometer, item 30. Belchometer, NBW dated 11/9/2015. As per the instruction, present petitioner was on bail during trial and notice to the bailer.
1,000. 1,000. Yes.
31. 31, my lord. I am also seeking the passing of the NBW money.
Yes. You are on bail?
My lord, I was not on bail. What had happened in this case is the Honorable Court had given me this opportunity that in the event of arrest, I shall not be, my lord.
Acha.
But what has happened is thereafter I went to the police. I asked them, I gave them a copy.
And they filed it showing you absconded. NBW.
My lord.
Right. Petitioner was earlier petitioner was admitted to anticipatory anticipatory. However, the police without informing without issuing notice to him filed the charge sheet showing him his absconder, which led to the issuance of NBW by the court below on 26/6/2023. 500. Yes.
32.
The lordship bail granted on 3/10/2023 and NBW issued on 18/9/2024.
Yes. 500.
Grateful.
33.
Petitioner was admitted to interim bail. Thereafter, the Honorable Court granted liberty to approach the court below for extension. For a moment, your lordship may have a glance, page 85.
Yes.
In fact, 85. The last sub paragraph.
Yes.
28/24, the case record posted to 28/4. The accused Pradeep Das was brought to the court by means of an ambulance. So now after he was released for 3 months for renal treatment or transplantation.
Brought to report, yes.
No, prior to that, again detected heart problem. That also been reflected. Now the NBW has been issued.
I'll cancel it, but
Send him back his.
The petitioner was always all throughout interim bail.
Yes, interim bail.
See the condition, he was brought in an ambulance. What will you do with this kind of people? You are not admitted to regular bail so far.
No, my. No, my.
Why don't you ask for regular bail?
My lord, in fact, I have approached. This honorable court said, unless you go inside, regular bail cannot be.
And your interim bail period is over.
And this honorable court also granted liberty me to seek extension before the London trial court. And looking at the condition, trial court was granting.
Extension application is pending.
Pardon, my lord.
Extension application is pending.
The extension application rejected. The last extension application rejected.
And
NBW issued.
Petitioner was admitted to interim bail by order dated 22/3/2024 for a period of
3 months.
3 months. For a period of 3 months. After expiry of the 3 months, he moved an application before the court, before this court for extension of the interim bail. This court by order dated. This court relegated the petitioner to
28/6/24.
28/6/2024 relegated the petitioner to move application before the trial court. Accordingly, the petitioner moved the application before the trial court for extension of the
from time to time
for interim bail. For interim bail, the said application was turned down on the ground that the petitioner shall surrender. Then only the application could be considered, and also NBW has been issued. Mr. Das had taken me to the imbue order. The imbue order reflects that the petitioner on 2/8/2024 was
that was 24/8, my lord.
24/8/2024 was produced before the court by bringing him in an ambulance. His health condition is precarious. Therefore, he seeks indulgence of this court. Regarding head to the aforementioned facts, the NBW issued by the court below by the order dated
4/10/2024.
4/10/2024. The execution of NBW dated so and so, issued by the court of so and so. Court of which court?
Additional District and Session Judge Omar Court.
Omar Court is stayed till 31st of December, and the
Can I pray little more?
The trial court is directed to decide the application of the petitioner for interim bail, which is pending before it. Yes. Now let the application be decided. Yes.
Grateful, Your Lord.
Yes.
34.
And he was on bail on by sitting the other order. And NBW issued on 9/9/2020.
22. Okay, 500. Yes. Yes. 35, sir.
The Belgium matter, the issue of NBW 28/24. And date of release 11/8/21.
500. Yes.
36.
That's it. Bail was granted on 30th September 2003 and the NBW was issued. 17/5/2022. That's it.
22.
Yes, ma'am.
1000. Yes.
37.
But there is a defect in this bail with defect, Your Lordship. The defect is to be removed.
Non-APS for the petitioner in the interest of justice at that, yes.
38.
Item 38, may I please, Your Lordship? Pursuant to the order dated 4/12/24, Lordship had directed me to file an additional documents on behalf of the petitioner to substantiate my case. Lordship, if will permit me.
Additional documents that have been provided by my friend, I need some specific directions as to that case. But the inspector who is in charge in that case, she is on training, Your Lordship.
In view of the additional document placed by the petitioner in the file, the State Council seeks adjournment to get instruction in that regard. Please the matter, this side of the case.
Your Lordship, if I may be permitted for 10 minutes at least to make submissions on the matter on the basis.
If I'm adjourning, why 10 minutes?
So Lordship, he is actually the.
Hey, let him seek instruction 10 minutes. Within 2 minutes, I'll decide your application. 10 minutes regular matters. Yes. You have a case. How you are custody since
9 months, 6 March.
9 months. Offense?
Offense for cheating, criminal breach of trust, misappropriation of money.
To the tune of 3.70 crores.
It's 4.2 crores, Your Lordship. 7 checks were issued.
Get ready to pay some money. Yes.
Obliged, Your Lordship.
Yes. How many cases are there against you?
No case. But the main petitioner, the first, we are 3 accused. First accused and the third accused, they are having criminal antecedent. First accused was arrested by the Bhopal STF.
You are running
I'm not
builder.
Builder. No, I'm not the conducting counsel in this matter. I'm only for the co-accused.
He is the branch manager.
I was the
asset management holder. 3.70 crores. Let it come.
You get instruction.
Yes, Your Lordship.
Yes.
1 week after.
He's already about 9 months. He's already there in the.
Yes, Your Lordship. 1 week after, Your Lordship.
Yes. Yes. Yes, sir. 39. Anybody? None pays for the petitioner in the interest of justice. Yes.
40. Adjourn.
No, in bail matter, if they don't come, I can't wait. Many matters. Yes.
I filed an extension of time, my lord.
Yeah, extension of?
Extension of time. Surrender. Extension of surrender, my lord.
Lordship, item number 38 and 39, they are the co-accused persons. He was released on bail.
No, 40. It is a disposal matter, my lord.
Disposed.
Relation on basis of the
granted bail where?
My lord. And a copy I have supposed to be served, my lord.
Condition, huh? Period of 2 months. 2 months is over.
My lord.
Have you surrendered?
No, sir. 2 months going to be over on Wednesday, my lord.
Wednesday, yes.
And your lordship.
What is the reason?
The reason, my lord, that the operation is going to be.
Where is your application?
My application is, my lord, IA number 1592 of 24, my lord.
Right. For the reasons stated in the application, the interim bail granted by this court by the order dated 7/10/2024 is extended for another
8 weeks. 8 weeks, my lord.
Why 8 weeks?
Because what operation is going to be held.
What operation?
My lord.
What operation?
Annex.
What are you suffering from?
Page 12, my lord. Page 12, my lord, he is taking the medicine, my lord.
Medicine, obviously, everybody. I am also taking medicine.
And my lord, page 9, your lordship, the certificate of the doctor, my lord. Adron. The subpubic lipodatic for which he is going to be operated on 2/1/2025.
Where are you reading?
Page 9, my lord, of my IA.
Page 9.
9.
Okay. 9. This is informed that from having supra TB and which is going to be operated on which is this hospital?
Well, it is a Solen of the two.
No. Which hospital is this?
Ankle pain, my lord. Yes, my lord.
But you have taken a certificate from a plastic surgeon.
Yes, my lord.
Plastic surgeon is giving the certificate.
Yes, my lord.
Lordship,
who will operate, my lord?
Item 38 lordship gola. He is the co-accused person in that case. Se jo Rohira jota 1 week after for further instruction bang raha. Now item number 43 he had gone in interim bail.
That's
he's the other co-accused person.
In item number 40, he is the main accused, and as far as the instruction from the petitioner is concerned, he has left the jurisdiction of this honorable court. He is seeking treatment at Ahmedabad currently. for his medical treatment, as far as the instructions are concerned.
You file response to this. Wednesday, matter is there, operation is when, on the first of,
Second of January.
Interim bail is expiring on
This Wednesday.
this Wednesday. Get instruction about it. Huh?
ତା ଆଗରୁ ସାର୍ ହେଲେ ଟିକେ better ହୁଅନ୍ତା.
I will take instruction regarding.
Tuesday. Instruction on this extension application.
Yes, sir.
କୋଉ ବୁଧବାର?
ये बुधवार
କେତେ ତାରିଖ କହୁନି?
ये बुधवार होची डिसेंबर 18
18 ତ?
18. Yes.
17
In fact, while granting this 2 months accommodation, Lordship had said if required, we will see there.
Extension, but see, I don't know which hospital is this.
Add-on hospital.
Plastic surgeon is giving. Plastic
No, sir,
surgeon.
sir, ସେଟା ହେଲା sir.
You are trying to enhance your beauty, it seems. You are trying to enhance your beauty.
ଗୋଡ ଫୁଲି ଯାଉଛି ଉଠି ବସି ପାରୁନି ମାନେ serious.
Why plastic surgeon will do that?
Those are plastic issues, my lord. Surgeon, Lordship may not go with the nomenclature plastic. They these things, veins and other aspects are read by plastics are not these vascular surgeons.
Anyway, may be correct. You may be correct. I don't know. Let us get a.
Asu. No, that we are expecting.
18th. Huh? And your operation is fixed on 2nd of January. Then 8 weeks.
The copy of the ID is served to me.
8 weeks minimum. Because 2nd January is the operation schedule. So the post operation also he needs some time again. So about 8.
I will take instruction from the hospital regarding.
Yes. 41. 18th. 18th.
The Lordship is calling on
18th.
18th, sir, for surrender date.
No, before that.
17th.
Let it be 17th or
Sir.
16th or 17th. 14th. Yes.
On
16th or 17th, whatever. Yes.
Sir, 17th house or 16th बहुत short ही है.
17th.
Okay.
Number ସବୁ ଥିବ ସେଥିରେ. If you want any further information, we are prepared.
Yes, sir.
41.
May I please your sim? Custody 9/8/2023.
9/8?
2023.
Yes.
60 kg ganja. Final pair Miller 28/12/2023.
Antecedents?
No criminal antecedent.
Yes. What do you say?
Sir.
What do you say?
So your lordship may kindly have a glance at this CD is not available, your lordship. But,
6টা order ଆଜ୍ଞା ହେଲାଣି ମୁଁ affidavit final pair ଦେଇ ଦଉଛି
that
minor
effect I'm trying to satisfy your lordship.
subject to verify of the criminal antecedent.
Lordship, that's what I'm.
Yes. And he is more than 1 year custody.
Yes, this is the state, your lordship. Prior to this also.
Final pair.
This is your letter. What happened?
He has not responded yet, your lordship.
Then why should he be in custody?
Lordship.
If this is so casually.
Lordship may kindly take note of this.
Yes, I'll take it. No, you have been writing letters after letters. No instruction is coming forth. Why should he be there in the custody?
Yes, Lord.
For your laxity? Petitioner, recovery is
60 kg, my lord.
60 kg as it 100 kilo below I am giving as it. Petitioner and so on.
How do you know?
Allegation is the petitioner so on.
Affidavit ଦେଇଛି no antecedent ବୋଲି ମିଳା.
You have to file it, huh?
Yes, with final pair.
Yes. The notice was issued to the state and state prosecution. Notice was issued to prosecution and case diary was called for. The learned counsel for the state while later dated 25/11/2024 and first लिखा इसला first 12/11/2024 5/11 also you have given.
Yes,
you have
sir.
given 5/11.
5 to 6 occasions, sir, lordship.
Yeah, right. So many letters you have given.
Lordship,
what is this going on? Mr. Raghunath also had given on as many as 5 letters. Letter goes about state through as many 5 letters sought instruction from the IO of the case, IO of the case. However, none of the letters issued by the state council have been responded by the value of the case. This is very unfortunate that the bail application is pending since. Bail application is pending since. When have you filed the bail application?
Since my lord,
So,
9
pending since 24 September 24. Despite repeated notice, no instruction is being furnished by the High Court of Orissa. Be that is the petitioner makes fun of. The petitioner is in custody since 9/8/2023. The petitioner has filed an affidavit today, inter alia, stating that he has no criminal antecedents. Criminal antecedents. Regarding head to the fact that what is the stage of the
no witnesses examined, though charge has been said. Till yet, no witnesses examined.
Petitioner further submits that although the charge sheet has been filed within time and charges have been framed, but no witness as yet has been examined by the prosecution. The petitioner is in custody since more than 1 year, 1 year, 3 months. 3 months. August 4, September, October, no.
9/12.
About 1.5 years. About 1.5 years. Yes, about 1.5 years. The trial is not proceeding yet. The recovery affected from the alleged recovery affected from the accused is about 60 kg or so. Like that. In the fact scenario of the present case, I'm inclined to enlarge the petitioner on bail. As the trial is not proceeding, petitioner is in custody for more than about 1.5 years, and he has no antecedent. Yes, guarantee.
42.
Yes.
Item 39, that is not called. Item 39 not called.
What? 39?
Item 39.
No, which item?
39.
No, this matter is what? 39?
No, 42.
42, you can't mention any time you like. I'm on the 30. I'm on 42 item number. Wait, you mention it right time. No, 42.
41 is called.
30?
After
Is it connected?
Lordship,
Is these two matters are connected?
Item 39.
39 and this matter?
No, sir, Lord.
Then with yes, 41?
42.
42? Yes.
42.
Yes. Non-appeals for the petitioner in the interest of justice. Short date also. All bail applications short dates. Yes.
43.
43.
Petitioner custody since 18/3/2024.
18/3/2024. 24. Okay.
Alleged offense under section
120B, 34 and section 4, which hunting.
Yes.
Actually, the
CD is there?
Yes, sir.
What are the evidence?
Kindly see the page 91. The rejection order.
He is in custody since 18/3/24.
Yes. Absolutely go no allegation against him also. Page 91.
Yes.
On perical of the record, it is ascertained that District Dohira, Kohra and Batashka was staying in Kali Biharingahata and maintaining their livelihood by cultivation. Dohira used to visit his village Kumardani to worship Ma Baradevi on every Thursday.
Where are you reading, sir?
Page 91.
91. Okay. Yes.
Relevant portion is the page 91 paragraph the witchcraft the Thursday. If any premature death or illness caused by local people, they blamed District Dohira as alleging witchcraft. Gunigardi. In the meantime, after death of Joni Digal, they suspected District Dohira for committing the act of witchcraft. The villagers called witch beating.
What are the evidences against these people?
Against this person, no, nothing is there.
1 minute, let me.
Only 4 witnesses.
Charge sheet has been filed?
provided.
Charge sheet has been filed?
Yes, Your Lordship. In fact,
No, sir. Evidence is going.
yes, Lordship.
Let us
Lordship,
see the evidence.
there are total 45 number of charge sheet witnesses. Out of them, four witnesses have been examined. And total 11 number of accused persons have been imbibed in the charge sheet, Your Lordship.
Yes.
And out of the 11, he is one of them in the charge sheet, according to charge sheet, Your Lordship. Lordship,
Actually, against him,
the whole story transpires the conspiracy by the village people to kill the old man and his wife on the very doubt that they used to commit those witchcraft.
Actually, that's like
Yes, Lordship.
the principal accused is Sunil Digal. According to present petition and other villagers went to Fulbani to call principal accused with an autopsy. At first, the accused Sunil Digal assaulted Batasi Kamar by means of hammer on her head, resulting multiple injuries, and she died at the spot. Then Sunil chased Dahira by holding a hammer, caught him near the river Girapatara, dealt a blow in her head, resulting in severe bleeding. Accused threw the weapon, the offense near the and fled away. Yes. The registration order Sunil Digal is the principal accused, but not the principal.
Yes.
Lordship, there since the last 5 years, there was 13 deaths in the village. And, due to that, the whole village made a conspiracy regarding this old man.
You don't tell the story. You tell me as regards Bharat Digal and Rina Digal. What are the evidence?
Admittedly, the main accused persons are this Sunil Digal.
What about these two people?
Nothing.
They have imbibed as the other co-conspirators.
Read the relevant part.
Yes, Lord.
Where they are implicated.
My lord, deposition tag one different.
Please matter next week. Please matter next week. Next.
My lord,
properly structure your argument.
Yes, Lord.
You can't tell me the story. This happened, that happened. In a bail matter, you tell me what are the evidence against these people. Evidence is now being recorded. If there is a specific allegations are there, and if any material is there, then it's
nothing, my lord. My lord, nothing.
Yes, next 44.
44.
My lord,
next week. Yes,
next Friday. 20th.
Friday. Yes. Next.
44.
May I please, Your Lordship?
Lordship, I may be permitted to put this, Lordship.
44. Next. Yes.
While the petition is custody 16/9/2023.
155 kilo.
Pilot.
16/5.
See what called for the report from the
16/5.
16/9/2023.
22. Okay. Yes. CD is there? Have you got the CD?
Yes, sir, Lord.
Yes. Yes. John Gomango. What are the evidence? 155 kilo recovered. So show me whether conscious position is there.
Lordship, in this case, Lordship had called for the report from the Sessions Judge.
Yes.
Gajapati, Lordship.
Yes. Acha, yeah, report has come. Charges framed, no witness examined. Yes.
I will permit to place. I will permit to place. This during course of Lordship plain paper FIR and so on so informed planted so that keeping of some suspected articles by one John Goman in his house. He digging that it was dug inside the floor of that house, Lordship. It was seized from that within the floor of the house, Lordship.
Yes.
An amount of 155 kg of
when it was seized, you were there present?
No, man.
No.
When the seizure had taken place, when he was arrested?
Also on 59/23, the seizure had taken place.
When he was arrested? Put it next week. Again, you are not prepared. Next week.
45.
The relevant questions you should be ready. The moment I ask, you answer it. And if you spend 20-30 minutes in a bail application, how will you deal with the other
It
matter?
will not happen henceforth.
You note it down, the date of filing charge sheet.
It will not
What are
happen.
the allegations against this accused? All these things, the moment the question is put, you have to answer it. Bail matter should take at least minimum 5-6 minutes, not beyond that. He's entitled. He's not entitled. It's all right. Yes, next week.
45.
Yes, 45.
May I please?
Yes, sir.
376 2 and 6 POCSO is there, my lord. Last week. Last.
This case, your lordship has already passed the order and your lordship directed me to, because 4 POCSO Act is there. So I have intimated the IO, and I also, my lord, sent the intimate that the case was listed on Tuesday, because on that impression was the Tuesday. And yesterday evening also I have sent a message.
No, I dictated the order, then we discovered that notice has to go.
Notice has to go,
Yes.
because in the past date CD has come. So I thought that notice must be.
Then what is the position?
See, we have already communicated her that matter will be taken up on.
Who is taking the
Notice was issued.
pass over? Pass over. We'll just take it. Yes. So whether you see order the number, number to the
Your lordship says also.
what the print out कर me.
Notice option.
46.
Yes.
May I please? I pray for interim bail, but petition support.
Interim bail. Have you checked it?
Yes, sir.
Yes. So,
Suffering for oral cancer.
oral cancer. Yes. What is his name?
Nanda alias Sushanta Naik.
Nanda. Sushanta Naik.
Sushanta Naik.
Yes. Petitioner rejecting from the case. FIR under section 2, allegation of the petitioner from. The petitioner is agreed by the order dated. Your bail application rejected by?
In bail appeal number 2907 of 24, 5924.
No. What happened in this?
If it is rejected, director was to the trial is expected and after general
Have you applied for before trial court?
Yes, sir.
Earlier, the petitioner approached this court for grant of bail on
page 16 and
bail
3
by filing BLAP number 2907 of 2024. This court by order dated 5/9/2024. Although rejected the application, however, granted liberty to renew the bail plea before the court below. The petitioner renewed his bail plea before the court below, which was turned down by the trial court on 6/11/2023. Hence, he has filed the present petition. Where during the pendency of this petition, petitioner has moved an application, being application number?
That is city case.
Application, interim application.
That is where city case number 320 of 27, next to 3 page 16.
No, interim application. This is for interim bail only.
Interim bail, madam. This is only for interim bail.
The petitioner is seeking interim bail. Interim bail for on the ground of on the notice was issued to the state by order dated 6/12/2024. Subsequent person is going to the state council has obtained instruction and the instruction the report reads regarding head to the aforementioned health condition as revealed from the report mentioned, reproduced above, I am inclined to enlarge the petitioner on interim bail for a period of how much?
4 months.
For a period of 4 months. 4 months, and after expiry, it is petition is directed to surrender before the court after the expiry of the interim bail. That the paragraph will be repeat and proper and all. Okay. Okay.
From the date of release.
From the date of release. 45 कोण? Upload is just check it out. Yes. Yes.
47.
I'm 45. 45.
My lord, petitioner is in custody since 31/1/2024, my lord. Offense under section 37.
Yes. 47.
My lord.
Yes, sir.
My lord, petitioner is in custody since 31/1/2024, my lord. Offense under section
31?
1. 2024, my lord.
24. Okay.
My lord, offense under section 372(9)(n), 419, 420, 506 by 34 YPC and
Yes.
66C.
Show me 164 statement.
My victim, your lordship, this is second round litigation, my lord.
Yes.
Your lordship directed after review, after examination of
All
victim.
right. Show me 164 now.
Already victim deposed, my lord. Page 16, my lord.
16.
My
1
lord.
6. Okay. 1 6. Where is that? 1 6. Okay. Let us see. You are Ajay Kumar Das, huh?
My lord.
8 months prior to the proceeding. After my marriage, I came to while Yes. What do you want to see from this evidence?
My lord, evidence, my lord, your lordship kindly cross examination. On 11/8/2023, I was blessed with a girl child, my lord.
Yes.
FIR has been registered on 28/1/2024.
28/1/2024.
24.
Okay.
And occurrence taken place, my lord, she stated that
8 months.
prior to 8 months.
Uh-huh.
And she stated that I was staying in my in-laws house at village Panikhada and carrying pregnancy of 6 months, my lord. She was staying, my lord. This is a totally false case, my lord. And married lady. Petitioner is a married person and the victim is also a married person, my lord.
I was staying in my in-laws' house.
Carrying, I gave birth to my daughter at
6 months.
Bhumika
So, then 6 months from 11/8/2023, 6 months. Then, and the incident has taken place when?
Incident, she has not stated, but only stated that prior to 8 months of
when the FIR was registered?
FIR, my lord, 28/1/2024.
January 8 months.
March 23.
March, what is the date? Let us see the date. When the FIR was registered, January. And this is January 8 months. Yes, what do you say? No, that's the part. What he's trying to point out. 24 January, the FIR was registered. He says that 8 months back, I have been raped and all. And the cross examination, she says that on 11/8/2023, she delivered a baby. So that time, 8 months back means she was heavily pregnant that time. The medical evidence show me. Right of petitioner. Show me the medical evidence. The victim in the present case, a victim prosecutor in the present case has already been examined as PW, PW1 on 29 November, 29th August 2024, November 24, November 24. No, 8th November 2024. So 8th November 2024. The prosecutor is 29 years of age. She in her examination chief has stated as under para 2. Page over para 2. However, in the cross examination, she has stated as under para 4. Reading the aforementioned state evidence, the Land Counsel for the petitioner submits that the FIR in the present case, the FIR has been registered on 28/1/2024. As per the version of the protocol, 8 months before the date of FIR, she has been subjected to sexual intercourse by the petitioner on the pretext of providing her a job. If the prosecutor says deliver a baby on 11/8/2023, 11/8/2023, the obvious that the victim must be heavily pregnant by the time the incident alleged to have been taken place. Apart from that, the counsel for the petitioner has taken me to the medical evidence. The medical evidence reveals as well. If need, medical reveals as well. So the petitioner is in custody since 31/1/2024. The prosecutor has already been examined. The evidence of the prosecutor is not been corroborated with the medical evidence, and the statement made by her in the examination in chief is partly demolished in the cross-examination. Partly demolished in the cross-examination. Because we had to the aforementioned, I'm inclined to admit the petitioner on bail and being instructed by proper. Yes. Hello.
What the case?
Yes.
Miller. Here is a case, Miller.
Next week? Next week, please. Next week.
49.
The offense is?
302 Miller. Okay.
Which one?
Which one?
Just read and tell me what are the allegations and what are the material against these people.
No eyewitness to the
Don't tell me the story, okay?
Miller.
Yes.
49.
May I please, Miller?
Yes.
In that case, my learned friend Mr. Santosh Kumar Burma Miller, appearing on behalf of the claimant opposite party. Notice has already been served. He made a request to pass it over because he has no objection. He has expressed before me that he has no objection with regard to restoration of this TMAPL, but it has come for consideration of the limitation point, Miller.
What's the delay?
Miller, things is delay. You'll assume me kindly appreciate, Miller, that is the fault. In fact,
what is the extent of delay? Let us know.
Miller, the accident, it is the accident appeal, Miller. It was preferred by the insurance company. You will assume me kindly appreciate on 5/8/2018.
You are for insurance company.
Yes, Miller.
Leave it here.
Miller.
Okay. Leave it here. Insurance company, you are challenging what?
Miller, we are challenging the imposed award in the appeal, Miller, passed by the London Tribunal, Miller.
What is the award amount?
Miller?
What is the award amount?
Miller, that award amount is, Miller, I'm just.
What is the award amount?
Miller, I'm just trying to help you, Lordship, instantaneously. Miller, amount is 2,45,520, Miller.
3 lakhs.
Miller, that it is a latch on my part, Miller. It will be a stigma for me, Miller. Your Lordship may kindly appreciate.
No, I will clarify that. No, I will remove the stigma. Insurance company.
Miller, it is.
Why should?
Miller, I will be inducted, Miller, indicted, Miller, person, because for the reason that
I will clarify that part.
Miller,
I'll clarify that part. Don't worry. I'll not
Miller,
interfere in the
Miller,
matter
Miller,
only because
next
of the
week-
reason.
Next week it may be on merit, may be disposed of, Miller.
No, what
This-
merit? I'm deciding on merit only.
Yes, Miller.
I will reject on the ground of limitation.
Miller.
I'll not restore it because it is an appeal by insurance company.
Miller, it is a
And
it is a CMAPL, Miller. It is a CMAPL,
I
Miller.
understand it. I
Miller,
understand. In the ground of
limitation.
delay, I'll dismiss it.
Miller, your lordship delay is on my part. Your lordship can appreciate what is
Kindly
my bona fide.
kindly see your application. What have you written? It's not
Miller, your lordship may kindly appreciate my explanation, Miller. Your lordship may kindly restoring appeal कर दे मेरिट रे आरो वीक कर दियो तो किसी नहीं अदर योर लर्सी में appreciate what is my
once I restore it will go to somewhere.
no Miller, it will come
It will not
to
come to me, and I want to dismiss it.
Miller, limitation may be condoned, Miller. It may be disposed of in that spirit. Your lordship may kindly appreciate what is my bona fide.
Pay 50,000.
Mohodavi.
No, you can't. Insurance company, you can't.
My lord, I have to pay. No,
I will protect that to that extent. I'll protect. But
Miller, आगो को expense अच्छी पुनी छोट अच्छी पुनी बंद कर जियो.
But see, try to appreciate 3 lakh rupees.
Miller.
And for 3 lakh rupees, how many years he struggled?
Miller, your lordship.
And you got it now. You file an appeal against that.
Miller.
That is dismissed in default.
Miller,
and you are trying for restoration.
Miller,
a delay of how many days? I don't know.
Miller, factually there is no delay, Miller.
You are harassing unnecessary.
Miller, that is my lord and friend is also agreed with my request, Miller. He is there, Miller.
It's not matter of the lawyers. It is the
Miller, I understand.
Insurer who has suffered so much.
Miller, it will come before your lordship.
And restoring is injustice to him, basically.
Miller, it is a Miller. Sometimes Miller, we are doing 0.1% our latches is there.
That's
and
right.
Your lordship is our strength to protect us. Your
may
lordship is there to strength. Your lordship is our strength to protect us, Miller. 0.1% mistake must be there to all these human being, Miller.
No, that's right. I'm not on that.
My part, Miller.
But I am just wondering, the award is of which year?
Miller, that award is of 2000, Miller. 2010, Miller.
Just see, for 3 lakh rupees,
Miller.
This man might be wasting a lot of money on this. What will he get at the end of the day?
Miller,
what are we doing?
Next week it may be disposed of because all parties are there, Miller. Mr. Brahma is appearing on behalf of all of the parties. Miller.
You have deposited the award amount.
We have deposited the statutory amount, Miller. Statutory deposit.
Award
Otherwise,
amount.
your lordship may can direct to deposit the award amount. We are ready to comply.
You deposit award amount and
Miller.
pay cost, and it will be disbursed to him.
Miller.
And keep on fighting the appeal.
Miller.
Keep on fighting the appeal as you like. Deposit the entire amount. Entire award amount?
Yes, Miller. In the registry of this honorable.
No, it will be disbursed to him. I will not allow the insurance had to get it.
It may be
No,
restored then
otherwise,
next.
otherwise I'll dismiss it.
Miller,
You
next,
think over it.
Next
Yes.
week, Miller, it may be.
Monday, you think over it and tell me. Monday, you try to see.
Miller, we are supposed
we
to
can't do injustice to people like this.
Miller, there is a latches on part of your lordship officers, Miller. We are a bona fide officer. We have devoted 3.5 decades for you to serving before lordship, Miller. Miller, 0.1% latches must be there.
I'm fully with you. I'm not doubting you are this thing. But I'm only worried about one thing that 2010 award. And this man is fighting, he's not getting.
Miller, on that ground, next week it can be disposed of because insurance company latches is up to 2016, Miller. There was a peremptory order passed by this honorable court. Within that peremptory order, I have filed a miscase.
And there is a notification also, just check it up in the insurance company. If the threshold, they have decided the threshold, they will not appeal for it.
Miller?
If the award amount is a particular threshold they have decided, they will not appeal for it. This kind of orders are also there. There is a circular.
Miller, it can be despised.
Monday you come.
Monday.
Yeah,
it may be restored, Miller.
Restore with the cost. I said I'll restore it. Deposit the entire award amount.
Yes, Miller.
Cost, pay the cost, I'll restore it.
Your lordship may kindly pass to that.
Yes, I'll do pass the order. Right.
Miller, we will deposit in the registry. Otherwise, our appeal will be redundant, Miller.
I'll
Obliged for that.
Order. I'll allow it. I'll allow it with this one. Yes. Give it to me.
50.
Yes, 50.
50 minutes I am for the opposite party minutes, EMAPL.
Are you opposing?
No, opposing minutes in the sense, effect is there. Petition minutes, there is a
Who is
defect.
appearing for
My
petitioner?
lord and friend is appearing.
Yes.
Says that there is a defect, non-removal of defect as per SR minutes.
And another thing is that they have filed an IA for the condonation of delay. That is 28 days.
Condonation of delay is your consideration.
28 days.
Delay how much?
28 days, ma'am.
They have shown it 28 days. To me, ma'am,
At least he is entitled to relief in this case.
Milord, it is, I am not, there is no laches in this case on my part, Milord.
Okay, for the reasons stated in the application, the
recording
delay is condoned. This petition is allowed and restored the, what restoration you are asking? Which
That is rate petition number 6771
yes,
of
rate
2018.
petition number, WPC number 6771 of 2018 is restored to its original file. These the rates for final disposal before the
Milord, in that case, I have no laches, Milord. In the other case, you will ultimately.
I will have to balance it.
that has been done. That has been done. So recording.
I'll have to balance it. I'll record that.
Milord.
I'll have to balance it. See, both the
I'm
things.
not there, minutes only to record my objection.
Objection. Mahapatra, sir, please. Yes.
I am repeatedly making prayer for the earlier item. Not for this item.
And you appear in two matter. In one matter, full relief you got. 50% you.
Milord, I am always bona fide because I am not.
I'll look. I'll just see what can be done in that case. So to balance. Yes.
51.
51, my lord, that second appeal has been dismissed due to non-compliance of the.
Is there any opposition?
No, there is the compromise was made. Your lordship can be fix a date.
Yes.
I have annexed the compromise petition.
Notice has been issued.
Mr. Ratha has already appeared. Gauri Shankar Ratha. His name has not been disclosed in the.
The name is not written on how they come. Delay? How much delay?
1181 days delay.
Oh, then Mr. Ratha has entered appearance for opposite party, but his name is not reflecting in the cause list. Let Mr. Ratha reflect in the cause list. Please matter.
May I pray only one line, my lord? Let both the parties be appeared and it will be disposed of because the compromise petition already filed before the Honorable Court.
Call him.
Yes, sir.
You do one thing. You call him. I'll allow it. In tomorrow's
tomorrow because they will
tomorrow's National Lok Adalat, I'll list it. Bring him.
Monday, your lordship in the court. Because I
Today you bring him, I'll restore it and place it before Lok Adalat and it will be done. You have settled the issue. What is the problem?
I have to intimate Mr. Ratha. That is
You
the
call
whole.
him, I'll pass it over.
Yes.
Call him.
After last,
I'll restore it and list it before the National Lok Adalat
Yes,
tomorrow.
Yes.
And since you have
it will be end for all
it will
times.
be over at least. Yes.
One passover matter, item 23.
Yes, sir.
If your lordship can take it up or after
23.
minus.
If you, it is a big matter, what?
No, small matter. For recalling of witness only. Rejection order for recalling of witness only.
311 is rejected.
311 rejected.
NIA. You want to re-examine whom?
PW1, the complainant himself. And I have in my application stated that only on the date that will be fixed, I will complete examination and clear. And here is a case, because 5 times my case was transferred because he went from one court to the other millers.
2016 complaint.
Yes. So 5 times my case is transferred. 10 times millers.
Who is appearing for opposite side?
First time it will come, your lordship.
Issue notice. Issue notice.
Pray for stay of further proceeding.
You move application. No?
I have moved. That is application.
You move an application there for adjournment. I just record it too.
I have had an IA here, millers. Date
is generally
date is fixed to 20th.
2016 complaint.
No, what has
and
happened?
the statute demands that within 6 months it has to be completed.
I have given the entire order sheet. Your lordship will find.
In 8 years now.
No, I understand. And all the fault is active. I have not taken adjournment. Barring 2 occasions, your lordship will the entire order sheet will out. Because 5 times case is transferred to other courts. And the no notice was there. Both the parties we are remaining absent because of want of notice. We are not
take amount.
This is one.
What is take amount?
Take amount because it's a fake case altogether.
No, what is take amount? You tell me.
It's a 8 lakhs. I should have proceeded because in 480 because 2 cases.
Generally, what I do is I impose a cost of about 25,000-30,000 rupees to be paid to the complainant, and I give one of it.
But this is the case.
That general order.
Once your lordship will go through order, your lordship find 10 times not at least barred because of agitation, your lordship knows the Bhubaneswar, the case to transport.
You want me to see? You want me to dispose up? Then I will impose little more cost, expert if you want. Otherwise,
no, it will take some time because I will take your lordship attend to order to be lost. Your lordship will
I
find.
did not go. It is a 311 application. You want to cross-examine complainant.
That's the only prayer.
Then therefore you pay the cost.
I have no contribution to the delay, my lords. I will extend. Your lordship will find 10.
Then I will issue notice on. Yes, notice.
Order stay up for the proceeding because
138 matter. There is a statutory bar. I can't do it.
No,
I couldn't do it.
No, that was statutory bar, my lords.
No, yes, 6 months.
Yes,
it has to be concluded within 6 months. That is the statutory command.
And your lordship will find.
And contrary to the command I state, then how can I state? Like
none of my fault. Order set to
if there is a statutory period fixed for the completion of trial at the instance of superior court, the proceeding should not be stayed. Simple principle.
But the PO on deputation, PO on CL.
Whatever. I have to examine it.
Bar on agitation.
Therefore, I'm saying, if you want, I can allow it right now.
Cost may also, I have no fault.
Without cost, I can't do it.
I have no fault. Your lordship will. My lordship realize.
Standard order. Anyway,
going through order set, your lordship will realize.
Issue notice sorted the before this side, if possible.
Date is fixed to 20th December, minutes. The date is fixed 20th.
No application for adjournment of that. Yes. Yes.
No, let one thing. Your lordship will direct me to move there so that. Order it?
58. Who is appearing? Rogada is not here. We want an adjournment.
Yesterday, I was submitting the
Okay, adjournment, the personal difficulty. Mr. Rogada has come to oppose you. He's 58 seeking an adjournment. He has some personal difficulty. Small matter, but he is personal difficulty. Yes. I'll take it up, sir.
May I just make one request, Lord?
57, my lord.
57 is likely to
Item
come up.
57.
Yes.
I'm being led by Mr. Mishra.
I have a little request, Lord. I have to attend somebody's cremation at 2 if it can be taken at 3, Lord. That's the only request.
My lord.
Yes, I'll take it up. In any case,
2, I may not be there, Lord. All I'm saying is if it can be taken at 3, not 2 o'clock, I have to attend somebody's last rites, Lord. So it could be
okay, 3 o'clock. No problem. 3 o'clock. Yes.
3 o'clock, Lord. Grateful, Lord.
Yes. Yes, sir.
Item 62.
62.
I'm ready. But I do not know whether the message is busy or not. So after lunch, I have some difficulty. I will still there.
I think before 3 o'clock, I can take it up. I think I yes.
You also kindly reflect that, my lord.
That I'll
kindly.
The best course would be I will allow your petition. Best course is that.
Ultimately, lordship will allow me.
Ultimately, the same cost I'll impose.
No, you
and particularly when a senior counsel of your stature is appearing, it should commensurate to your status.
I am sure.
Cost should commensurate to your status.
I am sure.
So if I impose a lesser cost, it will insult to you. So therefore, I'll.
He has already taken the deal.
That I have already said.
Pardon to mention, my lord.
I'll come after lunch.
Appeared and I requested about the change of date which was reflected in the order sheet. But I have filed.
Oh, yes.
But as per the official procedure, I have already filed an IA for.
IA will be listed on Monday.
Who bless me?
Pardon your lordships. Maybe pardon your lordships. Item 67, your lordship. Item 67 on your lordship's board. May I pray another day? They have filed a counter. I'll receive it.
I'll take it up. I'll take it up. Yes. Okay. Yes. 65.
Item.
Personal difficulty.
Lordships, item 67 also.
I issued a check, my lord. My problem was, my lord, at the time of issuing check, I had not verified the account. So the check bounced. Thereafter, I requested him to return the check so that I will pay you through account transfer. I paid him 3 lakhs through my account, my lord. That is admitted case, my lord. Now, my lord, he didn't return the check. Rather, he issued a notice to me under section
Whatever all these
138.
things are your defense.
No, defense. How is the subsequent development is also there, my lord. I have filed a further affidavit. That also, my lord, another story has been created there, my lord, in an FIR. Lost by them, not by me, my lord. My lord, now, my lord, I filed a complaint case against the opposite party, my lord. That was registered as, my lord, that will, your lordship will find at annexure.
What exactly you want now in this proceeding?
My lord, I am challenging the order taking cognizance in a 138 case, my lord. My case is, my lord, that I first instituted a case, my lord, once is a complaint case, my lord. Their cognizance has been taken. Thereafter, after lapse of several days, my lord, with delay, my lord, he filed a complaint case under section 138, my lord. My lord, there, the learned magistrate, without notice, my lord,
by accepting
controlled
your,
the delay.
by accepting your story to be correct, what you are saying is you issued a check.
I have issued a check. Now he has instituted taking help of that check.
And
he has issued the check.
That you have not issued the check.
Yes. Now, my lord, another FIR is lost by him. Your lordship may kindly
That
have
is
a
not
glance.
the subject matter of this petition.
No, I have filed one affidavit, my lord, further affidavit.
State is not
My lord,
also.
no, state,
What do you, in this proceeding, what do you want? You say,
your lordship may kindly, what he has said in the FIR, my lord. Proceedings cannot continue, my lord. I have, for the self-same cause, my lord. Your lordship may kindly have a glance over the FIR. In the FIR, he has made out another story that one Rakesh Singh and Avinash Patra, not the present petitioner, my lord. They, he wanted to evade the GST and he paid the, rupees 6
all
lakhs.
this story, can I go into all these facts?
My lord, because,
He saying some fact, you are saying some fact.
because my
Cognizance
problem is
138.
that I have to face 2 proceedings now.
But this is not the subject matter.
And there if
You
you lost,
amend your petition, challenge this FIR, subsequent FIR.
subsequent FIR mu challenge karibini. Subsequent FIR is another part, my lord. The subsequent FIR they have given us different story. My lord, what I
But the
propose,
problem, you try
what
to
I
appreciate this
propose, my lord.
in one petition you filed, you want so
That
many
is correct.
things in this.
Why I am bringing all these things to your lordship, my lord? My lord, what I pray, your lordship, my lord, there is a possibility of compromise now.
You tell that
So
simply.
your lordship may refer it to the mediation.
You,
so that
your beginning sentence is informant is your friend.
Facts that you
And second sentence, what you said that you paid friendly loan. Third sentence, you said that it was God dishonor.
Yes.
And thereafter you paid 3 lakhs.
I paid 3 lakhs.
I don't know for what good reason you keep on paying to a friend who is doing all these things to you.
No,
How come he can be a friend? I don't know. That is to be notice. Let us see.
On good faith, I paid him. My lord, because he wanted some money.
Now he has filed another case against
my lord, now he has lost an FIR against 2 other persons. My lord.
Notice to opposite party, returnable so Mr. Mishra and counsel for the petitioner submits that the petitioner is very old friend of opposite party number 2 due to some misunderstanding in the business front. The check was issued, and on the basis of the paid check, 2 cases have been initiated against him by the opposite party number 2. There is the petitioner and opposite party are friends. He expects that the parties would enter into the out of court settlement. If you notice, the opposite party in the Interim, petitioner is given liberty to move application to seek the urgent notification. If such application is put, same signature. Yes.
My lord, this affidavit may be kept on record.
No, you file. Because
I will file it.
I don't have a record at all. Yes.
I will file it and
yes, file.
Item number 60, there is a compromise because you issues I mentioned.
Yes, next. That I have said. I have yes, I have said that you move up. Yes, sir.
Item number 60, there is a compromise matter. Before recess, I was mentioned before my lord.
60, there is a compromise. 60.
60, my lord.
The parties are there.
Yes, my lord.
Yes.
You said that at the time of there was a 6-7 was there. For negative 506 and 34. Subsequently,
has been compromised. Now they are rejecting to both the families.
The wife and husband, who is the informant, who is the?
Informant is the wife.
Informant is wife. And petitioner number one is the husband.
Yes. Another one is my father and mother. There is also party, but unfortunately they can't come because they're seriously. My father is a cancer patient. My mother is a.
Okay. Show me the injury report. What are the
There is
injuries?
no injury at all. As per FIR.
Okay.
Chupri Koshadi Magile.
Yes.
I
I got it. Who is the Elena?
Is present here.
Just ask her. For her. Therefore, the state council was directed that. Therefore, the state council was directed to serve the notice on the victim and informant to the IO of the case. Mr. Udi Jana, notice has been duly served upon the victim and informant by the IO of the president. Despite the sufficient notice, none appeared for the petition. For the opposition party. For the victim and the informant. Okay. Yes. And serial chal raha. Pass over your. And then now it starts from
51.
Yes.
51.
51.
One minute, I have already intimated to Mr. Doctor. He is not available to us. He is Wednesday.
Monday.
Monday.
Yes, I am there actually.
Yes, Mr. Rathar is there.
Yes, my lord. Actually, I didn't have the copy of the restoration application or the limitation application. Let it come next week. My friend, my learned.
What I was suggesting is it seems you have settled the dispute insofar as the RS
That's
is
exactly how I've been also instructed, but I am to call my client and he will be present on the day when your lordship will pass this.
1 week.
Next week,
I was thinking of sending the matter to National Lok Adalat since you have settled the dispute by restoring.
Lordship may keep it to next week, any date, Monday, Tuesday. I'll then your lordship can also send.
Yes.
With regards to that matter down, that's better whether it will be taken up today.
If all the councils are there ready, and I will take it up.
No, my lord, I am ready. I have got 6 cases. I have got 6 cases. He has got 1 case, and other councils are there also.
How many cases matters are there?
Point of law, my lord.
Totally kitne? Aji. Then we can proceed. We can proceed in that matter. Okay. How kitne meter miscellaneous rahela?
6 to 7 orders.
I'll just the matters which are listed for orders. I'll take it up within 5 minutes. We'll review. Yes. 5 minutes.
52 319 petition में parents accused होइछिन OP2 appear करना दे पंदा
OP2 service
and
376
awaiting service urgent. Yes, awaiting service. Yes, next.
my lord, interim order to continue.
Yes.
53 milots में kindly have order number 4 milots. The matter is before the Honorable Supreme Court milots for which.
Let me begin, my lord. IA, your lordship will kindly see IA 1213 of 23.
What is the status of the SLP?
It is pending milots.
My lord,
Kindly see order number 4 para 2
yes, I
milots.
have seen. Yes.
my lord, let me place my IA.
Which IA you're talking about? 1213.
1213 of 24.
What do you want? Yes.
I want vacation of the interim order. Your lordship will kindly see the petition that the cognizance order that has been challenged has already been dismissed by this Honorable Court in respect to other petitioners. The husband has deserted the wife and contracted a second marriage. That case is pending there 498A, 494. Your lordship will kindly see in the office record, he had cited the present petitioner number 2 as the wife. And the case is pending because your lordship has granted stay. এটা তার অফিসিয়াল আটকে আনিছি।
Let us see who is the petitioner here. Petitioner here is
498, 494 and 109.
Sanatan Diggal.
Yeah.
Class 9.
He is not the husband, my lord.
Yes, he
The present petitioners before my lord.
Okay, just a minute.
I'll just apprise the
Just a minute, let me finish. The wife and the children, they are starving because the criminal case is.
Who are these petitioners?
Petitioners are accused. The present petitioners are accused.
I understand. What is the relationship?
Explain, my lord.
The witness.
There was a marriage that
If
happened.
he tell, if he factually incorrect, then correct it.
My lord.
Let him say.
The
You tell me,
present.
Srimati Sanjukta Pradhan, you are appearing.
I am for him.
And what is the relationship with
Not
Sanjukta
with the
Pradhan?
present petitioners. They were witness to the second marriage. That is how they have been arraigned as accused. I have lodged an FIR. On the basis thereof, the case has been instituted against the husband and the present two petitioners. They have now, husband came before this honorable court, that was rejected, that was dismissed. The order taking provisions was confirmed.
This is the order you are telling.
My lord.
Yes.
Confirmed because I have given those documents that he is the real wife, the present petitioner is the real wife, first wife. And
Yes.
that has been mentioned in the office records. Nominated the present petitioner and the children are the present OP number 2 and the children, they are nominees.
Yes.
And on the basis thereof, the earlier petition filed by the husband here, that was dismissed. Cognizance is all right, you may take up, you may already raise all those points at the time of framing of charge.
Yes.
Subsequently, the other two persons have come, the present petitioners have come, and on the basis of a alleged SLP filed before the Honorable Supreme Court, where no interim order has been granted.
No, SLP against what order?
Against that order, against the dismissal.
Of the husband, my lords. Not the present petitioner.
This one.
Yes.
Against this.
Yes.
Of the
Sanatan
husband.
Diggal.
Yes.
Against this order.
Sanatan Diggal is one of the witnesses in the marriage, my lord. May I explain? The three petitioners before my lords are
Now the trial has been stalled. So the wife is not getting anything from the husband because 125 has been stalled on the basis of the stay granted in this court, in this case.
But the present petitioners, my lord, are three witnesses in the said marriage. They have no relation as to the relief that the wife is seeking from the husband. Now, because all these contentions have been raised before the Honorable Apex Court, the same is pending in an SLP. Until unless that is decided, my lords, the status of these three petitioners also.
Apex Court has not granted any stay. But on the basis of only because a petition has been filed, your lordship has granted stay. Consequently, the wife is not getting anything.
Where is the order of maintenance? Show me. Order of maintenance in favor of you.
Maintenance has not been given.
You are not getting means.
I have filed 125 petition.
That is not say.
No. I'm submitting. Because the criminal trial has been stayed, saying that she is not my wife. That is why the other petition has also been stayed there.
You say which are the petitions stayed? You tell me. I'll clarify it right now. This stay of the present proceedings shall not.
Submission before your lordship is that your lordship may vacate the stay granted by your lordship, or in the alternative, your lordship may dispose of the criminal miscase.
Because these three petitioners are not
the only thing. Let the petitioner.
relief that the wife.
That I need to hear both.
Let him submit.
I need to hear both the parties. Let's see. In interim order, it has been operating on the ground that some case is pending in Supreme Court. Unless I.
Let's see the order of the Honorable Supreme Court.
Show me against which order you have gone. I have not stayed your 125 proceedings.
No.
That is independent.
No. Yes.
And independent.
Your lordship has granted stay in the criminal case.
But how does it have a bearing on that?
It is a bearing.
Because these three petitioners are merely witnesses in the said marriage.
Second marriage.
Can the wife claim any relief from these three petitioners as to maintenance and that the children of the.
Let the charge sheet be submitted, charge sheet be considered. I have no objection.
Unless until all these contentions.
For final disposal.
Let it be
After vacation.
No, after vacation. If there is an objection, next week.
For final disposal.
You are good.
23rd minutes, 20th or 23rd minutes.
Because this SLP is not for you. SLP is for the other.
Yes, but all these contentions are
What a-
in that SLP before the renewal application.
I will for you, I'll dispose it up.
My lord.
I understood. The husband has gone in SLP.
And these three persons are the
If
witnesses.
you
of
are
the-
saying that I have nothing to do with you, the husband.
All these observations will make an
Whatever.
impact on the.
And you also file an SLP if I'll dismiss and go and get it taken. Okay. Yes.
Milos is
And
listing
there
it.
is a delay also. It is SLP is not even numbered.
Next
Yes.
week.
That's an old order. Milos, I gave the first order that was mentioned. SLP criminal number is 13153. It's numbered, Milos.
Yes.
No delay.
Okay. Yes.
Milos is listing it too.
He'll give a date. Wait. Give a date.
I'm grateful.
Wait.
54, my lord.
17.
Guru, my lord, notice onshore, my lord. The lordship kindly glance to page 38, my lord.
There is notice to be.
Service. Why service is not complete?
Onshore,
Huh? Address can't be located.
my lord, your lordship, for a moment, kind page to 38 page, my lord. This is the petition filed by the opposite party number 2, my lord. This is the address, page 38, my lord.
Yes.
This is the name and address, paragraph 1, my lord. Pujan Wall, Bhubaneswar, represented to so and so. Plot number 52, Idco Industrial Estate, Bhagavanpur, post so and so, my lord.
It is your petition. You have to give your.
No, my lord, this is not a petition, my lord. This is the opposite party number 2 petition, my lord.
But what can I do?
My lord, your lordship may direct for the purpose of publication, my lord. He is intentionally not accepting the notice.
Application for substituted service, I'll allow it. Move an application for substituted service, I'll allow it.
My lord,
Indicating the newspaper. Yes.
your lordship.
Service awaited. Land Council for the petition submits that he would be moving application for substituted service. Please the matter. Yes.
25, may I please? There was a notice was delivered.
Service.
That is flag C.
Service sufficient.
Yes, my lord.
It is appears.
Appeared.
Item delivered.
Anybody is
That
appearing?
is flag C. Postal tracking report.
Flag C.
Lordship.
When is it delivered?
No.
Hmm?
No one appeared.
Eh?
No one appeared.
Item delivered. Nobody appeared.
Flag C.
Yes, item delivered. Item delivered.
Here, my lord, this matter hasn't completely settled between the parties.
Next 4, it was the settlement, my lordship.
Yes.
Next 4, page number 26, they have filed an IE in the IE and next 4, page number 26.
If they settled, then why don't you bring him?
Yes.
Lordship, I have filed for quashment of the proceeding because
That's right. If you have settled, bring him. Why are you waiting for service?
the bank manager, the bank manager was lodged an FIR on the allegation that there are various 11 of tractors loan was sanctioned in 11 farmers. One of the farmers is the petitioner, my lord. Subsequently, a civil suit was initiated against the present petitioner by the said bank manager, who is the informant, and that the suit was ended
And a compromise.
on compromise that is my lordship kindly pays.
But it's all right. But suit is disposed of doesn't mean that the criminal case will be disposed of.
That's right.
Unless you bring him.
Yes, sir.
Lordship, but they are not coming, so because the poor farmer, man, he has liquidated entire.
Why are you telling us service? I'm waiting for service. You bring him.
Lordship,
Bring him. So that I can pass it.
Another interlocutory application I had filed.
Despite service, opposite party number 2 has not entered appearance so far. The for the petition submits that the pertaining to the same subject issue. There was a civil suit filed by the bank against the petitioner, which has been decreed on settlement.
Lordship.
Decreed on settlement. And therefore, he says that on the same terms of settlement, the present case to be put to a quietus. Despite notice, opposite party number 2 has not appeared as yet. In the interest of justice, adjourned to so and so, and the proceeding before so and so is stable. Yes.
Another I had filed. Lordship, while
for what?
Granting bail, 3 lakhs cash security was imposed. That is lying pending, my lord.
In this case,
Lordship, in the law.
I have stayed the proceeding, that's all.
Yes, sir. Grateful, Lord.
Yes, next.
66.
My lord, I have already filed a requisite, but neither it
Service,
nor-
service.
মানে
Huh?
fresh
Service is
requisite,
not-
my lord, fresh requisite may file.
Service is not complete. Service is incomplete. Fresh notice.
My lord, interim order may continue.
Huh?
Interim order is there.
Interim order continue. Yes. Yes.
57 was fixed for 3 o'clock. Yes.
Okay. Yes.
59.
May I please, sir? 59 rigorous imprisonment at 2 years.
Hearing. Huh? Orders. Yes. 59 years, sir.
Yes, my lord. Rigorous imprisonment 2 years for the offense under section 3(2).
Okay. Appeal admitted. ठीक है. Yeah.
Last occasion, confinement delay. But
I have admitted the appeal. Bail granted and relation of finance state. Yes. Item 2. Yes. Yes, sir. Item 2.
My lord, item number 64. My lord, not filling well actually.
Item 64 adjourn कर देंगे, not well. Yes. Item 2.
Interim order is there, my lord.
Yes, interim order करना. Yes. Item 2. Yes, sir.
My lord. My lord.
Yes.
Yes, if I may, my lord.
The point which, my lord,
Is your lord.
Yes, sir.
Lord, your lordship's called our matter. I'm sorry.
Yes, sir. No. There is another matter.
No, my apologies, Lord. My apologies.
Yes.
my lord, the point, my lord, at the last occasion, I had drawn my lord's attention.
Yes.
That after the judgment of Midakatana Pani, which has been reported in volume 79, 2022, CLT page 1, number of judgments have been delivered by different courts. My lord, including my lord, has also passed a judgment in that respect in criminal miscast number.
Where is do you have the compilation?
My lord.
Judgment. Give me. Compilation. Yes.
My lord.
Yes.
Wherein, my lord, in Minakathan Mani's case, this honorable court, single bench of this honorable court was pleased to observe that was the first judgment on this point with regards to departmental proceeding and criminal proceeding.
Come to Minakathan Pani.
Minakathan Pani is at flag F.
Flag F.
My lord.
Yes. Come to flag F. Yes. What is the ratio agent?
My lord. Yes. My lord, there I had raised this point. My lord, after analyzing,
come to the relevant
my lord, I'm just drawing my lord to that. My lord, may see page 93, paragraph 18.
Para 18.
So let me read it, my lord.
Next in chronology.
The next in chronology is the decision of State NCT of Delhi versus Ajay Kumar Tyagi, which is a judgment of a bench of 3 current judges, but which took no note of the earlier decision in Aditya Kejriwal versus State of West Bengal. What is, however, common to both the decision is the earliest of the decisions of the Supreme Court, P.S. Rajya. Well, let me kindly take note of P.S. Rajya versus State of Bihar, 1996, volume 9, SCC, page 1. In P.S. Rajya versus State of Bihar, the allegation against the delinquent employee in the departmental proceeding and the criminal case were one and the same, that is possessing assets disproportionate to the known source of income. The Supreme Court was of the view that the case could be brought under any of the categories of cases mentioned in State of Haryana versus Bhajanlal for quashing of the proceedings. Accordingly, the decision of the High Court declining to quash the criminal case was set aside and the criminal proceedings were quashed.
Yes.
In State versus NCT of Delhi versus Ajay Kumar Tyagi, the decision of P.S. Rajya was sought to be distinguished by stating that paragraph 19 has been quoted. I have also given the judgment of P.S. Rajya as well as Tyagi matter. Does not lay down any proposition that on exoneration of an employee in the departmental proceeding, the criminal proceeding and the identical charge or the evidence has to be quashed. Paragraph 20, my lord. In NCT of Delhi versus Ajay Kumar Tyagi, the Supreme Court noted that the decision of PS Rajya, which was by the bench of two judges, was distinguished in a subsequent.
Come to para 26.
I'll come to that. Why I'm reading it, my lord? My lord has taken note of Ajay Tyagi. Ajay Tyagi's decision has been taken note of by my lord and other courts also, but Ajay Tyagi has been taken to be per infinitum.
But ultimately it says,
my lord,
in view of Radhesham,
however, as per this,
come to para 26.
My lord, for all the aforementioned reasons, the facts and circumstances of the present case were on the same charges on which the petitioner is facing criminal trial. He has
been honorably exonerated in the departmental proceeding.
My lord, the
court adopted the reasoning of the decision. So the single judge has considered the reasoning of Radhesham and held that departmental proceeding is
Radhesham Kejriwal as well as Asu Surendranath Tiwari.
Yes. Yes.
My lord, I have given the reference of Radhesham Kejriwal at flag D.
Yes, flag D. Yes.
And most important paragraph is paragraph 38.
Flag D.
Let me see.
Yes. Flag D 38. Huh?
My lord.
Yes.
At page 58.
Yes.
7. In case of exoneration, however, on merits where the allegation is found to be not sustainable at all, and the decision and the person held innocent, criminal prosecution on the same set of facts and circumstances cannot be allowed to continue, the underlying principles being the higher standard of proof in criminal cases. That is the reasoning. That reasoning has been followed.
Para 39.
Para 38.
39 you read.
In our opinion, therefore, the yardstick would be to judge as to whether the allegation in the adjudication proceedings as well as the proceedings for prosecution is identical.
So that is the reason the single judge of this court had said you are directly not covered by Radhesham, but by going by the analogy of Radhesham,
single judge has clearly mentioned.
But see, Radhesham says if you are exonerated in the adjudication proceeding. And there is a vital difference between adjudication proceeding and departmental proceeding.
But here in all the cases, the word departmental proceeding has been used except in Radhesham Kejriwal. And this judgment has been clearly taken note of.
You show me one judgment where by employing Radhesham principle, the Supreme Court has quasi criminal proceeding in the departmental.
2022, volume 9 SEC. 2020, volume 9 SEC 636. Asu Surendranath Tiwari versus Deputy Superintendent of Police CBI. That is flag E.
E.
Mallet.
Flag E. Yes, flag E.
Mallet.
Asu.
Mallet.
This is also relied upon by the single judge.
That's it. That this judgment has also been taken note of by single judge.
Right.
Mallet. Wherein the analogy of Radhesham Kejriwal has been taken note of. Paragraph 38 has been quoted in paragraph 12. Well, let me see page 87. And 13, paragraph 13, paragraph 39 has been quoted. From our point of view, 38.7 is important, and if the High Court had bothered to apply the parameter, then on the reading of CVC report of the same facts, the appellant should have been exonerated.
Is regarding sanction. What is the fact of Asu?
Asu ballot CVC CBI ballot. UOW the DSP versus the DSP, UOW, CBI and another. It's a case of prevention. Paragraph 8, my lord, page 85.
both PS Rajya and Radheshyam Kejriwal has been taken note of. But the decision of Ajay Tyagi has not been taken. That has been taken note of by
page 86 at the top.
Ballot.
Just see.
Ballot.
Para 8.
Ballot.
Para 8. A number of judgment
have been
held that the standard of proof in
departmental proceeding being based on preponderance of probability is somewhat lower than the standard of proof in a criminal proceeding where the case has to be proved beyond reasonable doubt. In PS Rajya,
PS, this is important.
The question
PS Rajya was taken Bihar
was passed as follows.
Yes,
this PS Rajya has also been taken note of by the Lord and single.
Now you read that paragraph.
The short question that arises, well, that has been referred to and with the quotation mark in also in.
Yes, read that, therefore, I'm saying you are covered by this, sir. That's what I'm saying.
The short question that arises for our
consideration in this appeal is whether the respondent is justified in pursuing the prosecution against the appellate under section so and so, Prevention of Corruption Act, notwithstanding the fact that an identical charges appellant has been exonerated in the departmental proceeding
in the light of
the report submitted by the Vigilance Commission so and so. And it was answered subsequently and it was squashed. Yes, how will you come? This is the only issue you answered. He is covered by. There are two judgments. One is Radheshyam. One is this PS Rajya. And I
don't know.
And Asu Surendranath Tiwari. Two judgments are in his favor. One judgment can be distinguishable because that is a adjudication proceeding, not a department. You need not say that. Yes.
My lord, what happened?
That is the distinction.
My lord, before my lord, I was going through. Why? My lord was Meenakatan Pani's judgment was not referred before my lord.
Meenakatan Pani judgment loses its sanctity after reading 2-3 judgment of Supreme Court. That is a single judge judgment of this court.
And after
Meenakatan is only borrowed
in the 2022.
Meenakatan has borrowed the principle of Radheshyam
and Asu Surendranath.
And not relied upon that. Only he is persuaded.
Relied upon that.
No, the para 26 reading.
Let me see. Yes. It has been quoted. It has been quoted by because
para 26 is more important. You have to read that. The court, para 26 says the court adopts the reasoning of the decision.
This reasoning is at reasoning and finding is at paragraph 38. That has been taken note of.
Reasoning is then you have a difficulty. That is it. All are adjudication proceedings. Rather, you are directly covered by Asu and the Rajya. Yes.
So far as PS Rajya is concerned, Asu followed that PS Rajya. And that point of time, PS Rajya was not there because it has been overruled by that other case. That
Which one?
Other case.
Ajay Tyagi.
You will also can come to the other case.
Yes. Which
for that reason, I was drawing my lord's attention to paragraph 20 of single bench judgment. But my lord went to other Tyagi has been referred and how it has been distinguished, that is there.
Well, that's right. But if your entire case is on that single judge bench, you may not have.
I'm not on single judge because it's a past judgment of our High Court.
I understand. I read it full. Every paragraph.
Prior to that, Kejriwal. Kejriwal also not taken into consideration the departmental proceeding and PC Act offense.
That's right.
So, but there, the three judge bench judgment is there, where my lord has held that, where there is it's an issue where it involves offences of grave nature, involves question of fact and law. And my lord has held number of judgments, including three judgment prior to Kejriwal, that if the offences are grave in nature and involves question of law and fact, then the departmental proceedings should be stayed till completion of conclusion of the criminal case. That has not been taken into consideration by the Kejriwal. So, any case, Kejriwal is not related to, or is not helpful because
that my judgment is also there.
That is under the question of adjudication. So far as the Asu's case is concerned,
Yes.
that referred to Kejriwal, so Kejriwal will not be applicable. And another aspect is because that refers to application proceeding. Number 2 is PS Rajya. PS Rajya has been the PS Rajya M. Krishnamurthy. That is Department of Proceeding PCI. That was referred to the larger bench that is in Ajay.
Ajay Tyagi, show me.
That what Ajay Tyagi says. Then you also kind of come to other things.
Flag B. Yes.
I also saw, I know that how the Minokatan Pani is also not applicable, that is a core imperium judgment. Including that if Asu should not be here. Asu not taken into consideration the Ajay Tyagi, which relates to departmental proceeding and PCI offenses. And there the minor has held that the BK report manager, everything has been taken care of. Minor has held in page para 22. Their report 21, they refer to depot manager case. That is 3 judge bench argument. Their minor has held that it has not taken into earlier decision. Earlier decision of Kejriwal is one thing. And this time they have taken this Ajay Tyagi took into consideration the factors that earlier judgment, which are not taken into consideration, that is relating to departmental proceeding and criminal proceeding.
Yes.
Then 22, minor has held that according to that 3 judge bench judgment, held that if departmental proceeding and criminal proceeding based on identical and similar set of facts, charges in criminal case against the delinquent employee is of a grave nature, which involves complicated question of law and facts, it would be desirable to stay the departmental proceeding in conclusion of it. Then your lordship can see that is.
Where are you reading?
Order that is other thing. NCT was other thing.
Which paragraph?
Paragraph. That is.
Ajay Tyagi, you have not included.
Yeah, at flag B.
Flag B.
Yes.
Para 21 your lordship can see.
Para 21.
It is also mentioned that the decision of PS Rajya came up for consideration before 2 judge bench of this honorable court earlier in M. Krishnamurthy. While answering the identical question whether a person exonerated departmental inquiry would be entitled to acquittal in criminal proceeding on that ground alone, this court came to the conclusion that exoneration departmental proceeding ipso facto would not lead to the acquittal of the accused in criminal.
What I want to say, my lord, at this juncture, my lord, this was the submission of the government counsel while case was going on, because I was arguing this case before the single bench. I am drawing my lord's attention because of that only. My lord, may see paragraph 20 and 21 for that reason.
Yes.
For this submission only. Page 93.
Yes.
Let me see.
93.
Yes. On the compilation.
Yes.
In the state NCT versus Ajay Kumar Tyagi, the Supreme Court noted that the decision of PS Rajya, which was by the bench of 2 judges, was distinguished the subsequent decision in state versus M. Krishnamurthy 2007, volume 14 SCC 667, which was again by a 2-judge bench. It was accordingly held that the decision of PS Rajya was not an authority for the proposition that exoneration in departmental proceeding ipso facto would lead to a judgment of acquittal in a criminal trial. Despite noting the aforementioned decisions, the decision in NCT Delhi versus Ajay Kumar Tyagi failed to take note of the coordinate bench judgment in Radheshyam Kejriwal versus State of West Bengal. The latter judgment was binding on the coordinate bench, and therefore the judgment in NCT Delhi versus Ajay Tyagi should be considered to be per inquirium, as explained by the Supreme Court in State of Assam versus Ripa Sharma 2013, volume 3 SCC 63, and Central Board of Daud Bhora Community versus State of Maharashtra 2005, volume 2 SCC 673. Then we have the other 3 bench.
Ultimately, this paragraph says what?
Ultimately, this paragraph says Ajay
Tyagi per inquirium.
Per inquirium.
So Ajay Tyagi is for I am clarifying that. If Ajay Tyagi is for inquirium, then Ashu is for inquirium. Why I am saying to lots of
then, my lord, with all respect, my lord, my submission before at this juncture would be, I have also.
You tell me one thing.
My lord, 3, 4, my lord, I am drawing.
You answer that first.
My lord, I am.
See, Ajay Tyagi is a judgment of 3 judgments of Supreme Court.
That Ajay, Honorable Apex Court has not taken note of.
No, you just simply say Ajay Tyagi is a judgment of 3 judgments of Supreme Court.
My lord.
And the single judge of this court says that that judgment is perigurium because Radheswamy is not considered.
My lord, at this juncture, may I submit one thing?
I see this paragraph. I don't agree with it. With due respect.
My lord. My lord,
How can the single judge of the High Court can say that the judgment of 3 judges of Supreme Court is perigurium because Radheswamy is not considered? Radheswamy is all together in a different platform.
At this to answer this query,
I think in the single judge bench last paragraph is only helping you. You confine to 20.
I'm not question of help. It's a point of law to be decided by my lord for all times to come. Because that has also struck to my mind.
How can it be done?
My lord, answer has been given by Calcutta Full Bench 2001 SCC Online Calcutta, page 341. It's a full bench judgment wherein this point was raised.
Yes.
My lord, close everything. Per se, say that this judgment is per se illegal, palpably illegal, and not follow the principles of law in its true spirit. Can a single bench, coordinate bench of this court will defer it? No. Answer by the Apex Court is no.
But in the face of
it, no.
No, it should be
that has been answered.
Yes.
I will read the permit me, then I will read the judgment.
Which one?
My lord, that is 2001 SCC Online Calcutta. It's a full bench judgment.
Flag. Which flag?
I have not given it, my lord, because I know, my lord, this will be the point which will be developed by my learned friend. My lord, here paragraph 27. Let me see.
Yes. 27.
My lord. At this juncture, if a coordinate bench will face this type of problem, it should be referred to the Chief Justice, relevant papers before the Chief Justice to enable him to constitute a larger bench.
Are you suggesting that if I don't agree with that para 21 of single judge, I should refer to?
Well, it should be. Well, because for judicial propriety, but not for me. Well,
that's your submission.
What these clients will come and go, I am this concerned about.
Yes, sir. That is your submission.
Well, paragraph 27, let me see.
And then Minakatan has to be reconsidered.
It can be. It should be. If it is illegal, and my lord was pleased to observe, I am not agreeing with the view.
I think he'll consider.
Because my lord, no, my lord, because here, my lord, please, I have compiled, my lord, 10 judgments here. First, 4 judgments, 5 judgments are of Supreme Court. 6th judgment, my lord, is by this first judgment, Minakatar Pani. Then referring that or not referring that, some judgments of our High Court. One judgment, Honorable Justice Sangam Sahu has allowed it, referring Minakatar Pani, quoting paragraph 38.
Show me that.
See, that reason, my lord, I say there should be judicial propriety for the lower judiciary, my lord.
Where is that?
My lord, I am giving that. Yes. My lord, may see, first is G, flag G.
Okay. Yes, sir. G.
SK Sahu.
Yes.
Honorable Justice SK Sahu has taken note of Minakatan, Radheshyam, and Asu Surendranath and allowed it.
Yes.
My lord, we see page 99. Page 99. Here, the seven guidelines fixed up by Radheshyam Kejriwal has been taken note of. In our opinion, therefore, the yardstick would be to judge as to whether the allegation in the adjudication proceedings as well as the proceedings for prosecution is
para 39. That's para 39 of Kejriwal.
Court question.
Yes.
The aforesaid decision was relied upon by the three judge bench of the Honorable Supreme Court in Asu Surendranath, 2020, volume 9, SCC 636, and the view taken in Radheshyam Kejriwal was unanimously accepted. in then Minakatan Pani, paragraph 26, which my lord was referring. Sorry. Considering the submissions made by the learned counsel for the respective parties and the fact that the petitioner has been exonerated in the departmental proceeding on merit, which was on the same set of facts and circumstances like the criminal proceeding in GR case.
Reasoning in the decision.
My lord. My lord, next is. My lord,
What is the fact? Exonerating the
It's a case- it was a case of-
exonerating discipline reporting. Therefore, it is now let us come to my judgment. So unless I find two conflicting judgment of
My lord, next judgment, my lord, is Justice Pujari. I have given all the judgments. which I
and
got.
what Justice Pujari says?
He has not referred honorable
Minakatan.
court was pleased to not refer the Minakatan Pani and Asu Surendranath at the same Kejriwal and distinguished it.
Yes. Distinguish it.
My lord may see this judgment in total.
Yes.
My lord may see paragraph 9.
9.
The Learned Counsel for the Vigilance Department further submits the judgment of the Apex Court in the case of Asu Surendranath Tiwari as cited by petitioner is for inquirium, the submission which now he is making, my lord. In as much as it has not taken note of the decision in the case of three judge bench of state of Ajay Tyagi, and therefore honorable court was pleased to quote 24-25, and I have considered the rival consideration of the parties, keeping in mind the facts, the case, and at hand as well as the principle settled, admitted in the department of proceeding and so on, and accordingly dismissed. Here, my lord, paragraph 11, Radhesam Kejriwal has been taken note of. Paragraph 38 has been taken note of. Well, let me see paragraph 14, subpara, 6th line.
Yes.
Hence, the decision rendered in the case of Asu Surendranath Tiwari, which was relied upon the case Radhesam Kejriwala, cannot be said to be for inquirium for having not taken note of Ajay Tyagi.
No doubt there was a division of the opinion of judges, but for all the purposes, the same decision is rendered by the bench of three judges. So it is a decision of co-equal bench.
Therefore, the decision rendered in the case of Radhesam Kejriwal Supra still hold the field, notwithstanding the same being a decision on majority, and subsequently the bench of co-equal strength in an unity has taken a different view. That has also been answered in single bench. The 2:1.
Yes.
So,
see, last paragraph, read last paragraph of this Pujari statement.
My lord.
Reverting back, para 15.
Reverting back to the case at hand, while not accepting the submission of the Land Council for the Vigilance Department that law laid down in case of Asu Surendranath Tiwari is for inquirium, this court is of the view that in case of exoneration of petitioner in the Department of Proceeding on merit, notwithstanding the fact that the law laid down in Asu Surendranath Tiwari, reiterating the principles settled in case of Radhesam Kejriwal are reiterated holding this appeal, this court is not inclined to pass the proceeding.
Yes. Radhesam is declared.
How can I say what?
So it's my view is at the last. This.
My lord's view is flag J. Well, and my lord has taken note of Ajay Tyagi, my lord. Paragraph 12 at page 126. My lord was pleased to quote paragraph 24 and 25. And here, my lord, this Minakatan Pani has not been taken note of.
Yes. So there is a conflicting view of all the judges.
And Justice R.K. Patnaik also in one case allowed, in one case dismissed. I have given that also.
One not one.
Oh,
but the fact remains there are conflicting views taken by all the courts.
maybe my submission is, here the question of law as decided in the Minaka Company is not here. The question of law is here, in the Minaka Company, there is that not relates to, they refer to a judgment which is related to adjudication proceeding. Not a
Well,
single
adjudication.
No. Meenakathan Pani, departmental proceeding was there. Relying upon Radhesham, they quashed it.
It's fact simply. All the three judgments, my only senior is like, maybe it's casual.
We forget about everything. Meenakathan's, the Honorable Chief Justice, then Chief Justice of this High Court, has taken a view in Meenakathan. The issue was whether if somebody is exonerated in departmental proceeding, on that basis, if a criminal proceeding can be dropped or not. He said, relying upon Radhesham, he said that it can be done. I have taken a different view in my own judgment here. I said that no, Radhesham, Asu, nothing will happen because.
It's a question your lordship has to decide, what I humbly say, that whether adjudication proceeding and departmental proceeding is same. If it is not same.
But few court says same, few court says, I say no.
A single judgment say held that it is same. Rather, the other PS Rajyo, that is related to departmental proceeding and departmental.
No, now concentrate on the single judgment of this court. Forget about this.
Single judgment of this honorable court can overrule the judgment.
No, that's not the issue. Issue is if there are inconsistent view of different single judges bench of this court, it has to be referred to larger bench.
Where there is.
And you argue those things when it is referred to larger bench.
Supreme Court judgment is different, Sibo. Different view to
I can refer it to another bench to Supreme Court.
No.
Then I have to set right what has happened here. I have taken a different view than Justice Muralidhar. What to do?
The law is, if there is two different views of the Honorable Supreme Court of same singular same bench.
My lord, answer of my lord.
Not able to follow what I'm saying. You are not able to
answer of my lord friend is.
See, you are relying upon couple of judgment of Supreme Court. He is relying upon couple of judgment of Supreme Court. By considering both side judgments, the single judge bench of this court, three judge bench has taken three different views. So it has to be settled.
It is to be settled. My lord, my answer is. Fact को हमें जाऊँ नहीं करता हमें law रच्चू.
Point of law. What is the point of law?
Point of law is adjudication, whether adjudication proceeding and departmental proceeding is same.
That is not the question.
Absolutely not.
No.
Only that is
the point is whether if somebody is exonerated in departmental proceeding, whether on the same set of facts, can you prosecute him in a criminal proceeding? This is the case. This is the question of law here. And I have taken a view because they are relying upon Radhesham and say that yes, Radhesham in the adjudication proceeding they were dropped, so therefore criminal proceeding was also dropped. I distinguish saying that departmental proceeding and adjudication proceeding are different. The parameters are different. That view I have taken, but Justice Muralidhar's view is otherwise. Same Radhesham relied upon and passed.
So my
so therefore it has to go to
the answer has been given in 65 Supreme Court.
He is trying to say something, he is not able to perhaps put it.
The question of law is whether exoneration in departmental proceeding would lead to quashing of the criminal proceeding in a PC Act offence on the face of the sanction order accorded by the state government.
Why are you bringing sanction into it?
The law laid down in that case, different to that case, there was no sanction order, no PC Act offence, no, that was referred to adjudication proceeding. So here law is something different. Meenakathan is also different. Meenakathan, the issue about departmental proceeding.
Come to Meenakathan once again.
Asu Surendranath, my lord, it's a case of CBI. It's a case of CBI. Arbukai Koidur, you know.
Yes. Come to
Para 3.
Flag?
Para 3.
Flag, my lord, that is flag F.
Flag F?
My lord. Page 89 start.
Yes.
Page 89.
Prior to going to that, what are the their IPC offences? So also kindly postpone. IPC, that is relevant. IPC offences, he was punished in departmental proceeding. They prefer an state government prefer an appeal before the tribunal. Tribunal exonerated them. Next, he preferred an appeal before the tribunal, tribunal exonerated him, department. State preferred an appeal before the High Court. High Court upheld the order of the tribunal. Then the state preferred an appeal to the Supreme Court. Supreme Court decided the matter and upheld the order of the year and exonerated him. There the test was something different.
Only you concentrate whether it could be referred. It is not required to be referred.
Not required to be referred. Because three judgment relates to PC Act offence and departmental proceeding. That is, two judgments that were referred to that court, and Honorable Appellate Court of three judgment decided the issue, already decided the issue. And they are referring to, also refer to that judgment, PS Raja, which is no more at that point of time. And they are now, Honorable Single Judge has held that. No.
You tell me the judgment date of Minakatan judgment date.
Minakatan judgment, that is judgment date is, that is 20/2022.
And Ajay.
Ajay date judgment is 2012.
Then?
And he refers to that, and wherein the judgment itself categorically held that they are the CBC refused to sanction. That's why I'm placing that relevant para. Your Lordship, para 21, your Lordship can see that Ajay is there.
Yes.
But it's a
para 21.
It is worth to mention here that decision of PS Raja came from consideration before two judgments of this court earlier. Instead of Christian Moon, while answering an identical question, whether a person exempted departmental inquiry, you have the departmental inquiry.
Yeah, ipso facto.
Ipso facto.
Would not lead to the actual equitable
inquiry. Then next para 32. That the submission of Mr. Nageshwar Rao, they lacked the decision of PS Raja State of Bihar. The fact situation opening therein was absolutely different. In that case, the vigilance report the delinquent officer has shown to be innocent. It was at that juncture an application for quashing of the proceeding was filed before the High Court under Section 482, referring to Bhajanla, that was passed. Then your Lordship kindly turn to para next page, para 24.
24.
What my Lord said, they referring to.
Therefore, in our opinion.
Report manager was report that relates to report departmental proceeding, criminal proceeding. And other three judgments also referred, which has not been taken care of.
Therefore, in our opinion, the High Court to pass the proceeding.
Therefore, High Court passed the proceeding, misreading the judgment of PS Raja's case. In fact, there are proceedings to which we have referred to above. That is the depot manager and everything. That is referred to departmental proceeding. Therefore, they speak eloquently contrary view. Exoneration departmental ipso facto.
Would not lead to departmental.
There are 25. That para 24 and 25 has not taken care of by Malad Justice Muralidhar.
Okay.
And it's the case is it's a case related to PC Act offence, which is governed by the special statute. I will show other judgments also if your Lordship will permit. I will show other number of judgments where Malad has said that departmental proceeding and PC Act offence is something different. And because 13(1)(e) misconduct under PC Act is completely different misconduct under the CCA rule. If you take an example of a DHS, 13(1).
My lord, perhaps my lord and friend has not gone through Asu Surendranath. It's a case of PC Act.
No, what he says is.
My lord, there is a case of question of sanction. Everything is there in Asu Surendranath.
In nutshell, what he says is, if three judgment of Ajay Tyagi is clear, even if there is a conflicting view of single judges, it need not be referred to. This is what he says.
That has been taken note of in paragraph 21.
If there is and these three judgments is not noticed by the Honorable Chief Justice then.
Yes, that has been noticed. It has been noticed. Let me see. How can he say that it has not been noticed?
Yes.
That has been specifically mentioned. My lord, paragraph 21,
if in this
paragraph 21,
I think in this question, if you keep on doing it for 3 days also, we can't conclude.
My lord, page 93.
Formulate your questions and answer.
Page 93, paragraph 21. Page 93, paragraph 21. How Ajay Tyagi has not been mentioned.
Yes.
Despite noting the aforementioned decisions, the decision in state NCT Delhi, Ajay Tyagi failed to take note of the coordinate bench judgment of Radheshyam Kejriwal. The latter judgment analysis may be wrong, but that has been taken note of.
The ratio has not been considered.
Yes, should be considered to be
You
polynomial.
give your written submission. Yes.
And
I not read that, my lords. I'm just placing one facet of this proposition, whether because of cleavage of judicial opinion, the matter referred to the Honorable Chief Justice or Suni, or your lordship decide the matter, law is going to set you to rest, my lords. That's why, my lordship, this honor court I have to place all the propositions. One of the facets of this proposition is when the prosecution can be quashed. I'm placing that particular line, my lord. Your lordship is holding that judgment, the paragraph 25. I'm just placing one line only.
25 of?
That three judgments, that is the law, my lords, my lord. The ratio has not been watered down, my lord, still.
Which judgment you are?
That Ajay Kumar Tyagi. I'll just place one line. And here, my lords, there is a cleavage of judicial opinion. Matter was referred. And my lordship turn to paragraph 25, my lords. 25. Your lordship see the first line. Then your lordship can see the observation. We hasten to add, however, in the prosecution.
20?
No, I hope lordship got it. Last but one paragraph.
Yes.
25.
25 of Ajay Tyagi, no?
This is another way to set in every case in this particular framework. 25, Lord.
25
paragraph 25.
You have ACC. You have ACC.
Yes, my lord.
Precedence. Supreme Court or latest law will prevail.
Para 25, lords. Last page, my lord. I'm just placing one line. This is another approach, my lords. When it is for lordship got it.
We are here. We are the yes.
Your lordship has keep the first line. I'm placing from the second line. We hasten to add, however, if the prosecution against an accused is solely based on a finding in a proceeding, and that finding is set aside by a superior authority in the hierarchy, the very foundation goes and the prosecution may be quashed. Is it their case? This is the framework, my lords. Whether that case fit in this particular framework, my lord, for later Supreme Court, my lords. If the answer is no, my lord, that disposes matters, my lord. This is the test. This is the question I put to myself.
My answer is the latest judgment is Asu Surendranath.
No.
It is 2020. So Asu Surendranath has taken note of
earlier judgment of this earlier judgment has the precedence value.
Only I will add one line because they have argued well. But the law of precedence, as we thought also, the Supreme Court judgment, the latest will prevail over the earlier one. If with a coordinated bench,
no.
The Ajay Tyagi as well as the that Asu's case, both are three judgments. The latest one, Justice Nariman's judgment, my lord, that there they have not taken only defect we can find out, my lord, though we should not venture to do that. But Ajay Tyagi case has not been referred to. But that being the latest one, that is to be followed. But the otherwise, the High Court judgment, my lord, if the older judgment, earlier judgment will be there, that will bind upon the latter judgment.
I'm basic normal. I'm not too concentrate to that. 2017.
Each other
you filed this. I think I have to read more than
one line.
Let me proceed with it. And one more fact in my case, in item 5. But there,
see in the abstract, if you argue like this, where will I note? Somebody saying something, somebody saying something.
That is the problem we are facing.
And it's not a formality, it's a hearing.
Yes, that is.
Don't do that. I can't, I'll have to read myself. I'll read myself and do it. I don't need your.
I'll give a note.
Yes. You give. You give your written note of submission. No.
It may
my lord's mind. I have wasted much time. Yes.
Item 12.
And you file written note, Mr. Partros.
My lord, only 1 minute because my friend was referring to PC Act. Why PC Act is because then I am in a better footing in PC Act because under section 19.
I'm only deciding the principle of law.
That is
I'm not going to facts of the case.
No, my lord.
And almost all the cases are PC Act here.
No, I am not on facts because my
almost all the cases are PC Act.
But in my case, my lord, while deciding the writ petition, in my case, the proceeding was instituted and the DP I have challenged before this. And I'm fortunate this honorable bench, I will say, my lord, pause the proceeding, department proceeding, taking note of the fact in that affair and the proceeding. And that has been upheld by the Honorable Division Bench.
That's not, I am not going to merit
There, my lord, was quashed the proceeding, departmental proceeding, on the ground that departmental proceeding was initiated quite long a period when the name was recommended, his name was recommended for IS. There, on the ground of latches and a delay, the departmental proceeding was quashed, not on merit.
I will decide. You please
give the judgment only, my lord.
Don't pass on this one paper, then it's very difficult to understand. Notes with highlighted portion and whatever you want to say. You also just give it. Compilation I have read it. I'll read it in compilation. If any doubt is there, then I'll place it once.
Yes. That will raise us to events so that
yes,
we can clarify.
Yes.
We have forgotten our own cases, my lord, after hearing this long and lengthy points of law. We have forgotten our own case. But 157 item, Mr. Luthra probably will be appearing on VC.
Lord, I'm here.
I just remind my lords, out of the same affair, 2 cases your lordship posted it to be considered on 18 for interim. 3 cases posted on 18/12 for interim. I can show that order.
Not I'm not disputing that. Not that was the case of a company. I'm not for a company. I'm for an individual.
I'll tell you, lordship, what it is. I'm being led by Mr. Luthra. The facts are different, my lord. So
1 minute.
Let the same affair.
Let us see. I need to notice and tag. Let him.
Absolutely. If my friends will just allow me, Lord, just to point out, not just to give you a little reflex. The point, the distinction is this: I am a shareholder of a company, and I continue to be a shareholder. Now, all the shareholders
increase the volume little.
Lord, I am a shareholder. Can your lordship hear better now?
Yes.
Lord, normally, I always believe not. We Punjabis are a little loud, so but I realize that the mic was a little slower, so I've increased it.
No, it's all right. You are one of the shareholders.
Yes, Lord. I tell your lordship, I represent a gentleman, Lord, who's A4, one Mr. Sulabh Arya. Mr. Sulabh Arya is vice president of an entity called Goldman Sachs Private Limited, a Singapore-based entity.
I think voice from your side has to be increased. From our side,
Lord, I've increased it maximum. Is this better now, Lord?
Yes.
Or not? Just a minute. Another device. Allow me. I'll just switch to another device. Give me a minute.
General device change. That was we used to keep a lot of devices running here and then
for different codes throughout the country.
Device change means code, some other code.
One code over, that device gone.
Yes.
Now, Lord, if I make it, is this better, Lord? I hope this is better. Now, Lord, just to tell your lordship one minor issue. Just one minor issue. I am Sulabh Arya. I am the vice president of an entity known as Goldman Sachs Private Limited, PTE Limited. It's a Singapore-based entity. I am a shareholder of this entity called Nestaway Technologies, which is Nestaway. I was a shareholder of about 10.8%. I am now a shareholder of 1.2% still. Now, the gentleman who is filing this prosecution is Amrendra Sahu. He's the first informant. It's registered without any inquiry, not it being a commercial case, so that's a separate issue. But Mr. Amrendra Sahu claims that when the entire shareholding of Nestaway Technologies, all the shareholders were sharing their shareholding to an entity called CORAM PropTech of Navi Mumbai. That shareholding sale was predicated on a payment of 11 point some crores to him. That is what that there was the understanding that we'll give to 11 crores will come to him. Indeed, there was some talk of 11 crores, but the correspondence on record makes it very clear that the entire shareholding had to be sold for 90 crores and no additional money is to be paid when that correspondence is contemporaneous correspondence with him is very much there. Because the entity which started the audit said there's no question of making any payment of the money. His claim is that he should have got more for his shares. He's not got it. That is a purely commercial dispute. Now, just to add to your lordship, second issue, not which is important, is he initiates a proceeding in the NCLT. Now, may I just draw your lordship's attention to the NCLT for a moment? Very interesting, Lord. He initiates proceedings in NCLT, which your lordship will get. It begins at page 50, annexure 2. The relevant page is 58. So there is a company petition.
Yes.
And the facts are at 62, my lord, where he makes the same allegations in the NCLT petition.
It is NCLT proceeding. Okay.
Yes, Lord. Page 62 are the factual part.
62.
Yes, Lord. That's the factual part.
Yes.
Just have a look at that, Lord.
Yes.
Petitioner is approaching the tribunal on account of the acts of misappropriation, mismanagement of the respondents. Para 2, he says, petitioner is co-founder and minority shareholder of Arman Company, an innovative startup technology operating in the space of facilitating home rental for youth, technology that has faced unprecedented challenges, especially during the pandemic. Then he talks about how it was constituted, main objects, etc. What is important is not page para 7 onwards on the next page.
Yes.
He started saying how they were approached and how we were dishonest, and how, in essence, he was ousted from money that ought to be paid to. And he talks in para 9 that the amount of consideration was usually valued at 120 crores. And in para 11, he says 11.72 crores was to be paid out to him. And this payment has not been made in para 12 at page 66. So that's the gist of this case.
What this proceeding was initiated under section 7?
No, this proceeding was initiated not under 241, not operation mismanagement. My lord will get that at page 58.
Okay.
Not operation mismanagement is 241, 242, 244 of the 2013 Act. But what is more important is, Lord, while this proceeding is pending, he enters into a settlement agreement, and there is an order which my lord will find annexure 6 at page 92, where it is withdrawn in terms of the settlement. Kindly have a look at that order, Lord, annexure 6, page 92.
Where is this terms of settlement?
I'll just show that to your lordship. Not terms of settlement is are here. What is
Annexure 4?
Annexure 4 at page 80, man.
Come to the terms.
Now, I'm not in the terms. Would your lordship be kind enough to come to page 83?
Amrendra Sahu. Yes.
And he enters into a settlement with Nestaway and Aurum. Aurum is the new owner of Nestaway. I still have 1.2. My company still has a 1.2% share. Now, kindly note, if your lordship comes below the recitals at whereas A, in the year 2023, various differences and disagreements arose in Australia between Amar on the one side, that same, and Aurum and Nestaway. Pursuant thereto, in connection with the aforementioned differences and disagreements, Amar filed a company petition under 241-245 of the Companies Act, numbered as CP number 12BB 2024, Principal Bench NCLT, along with an I application so and so. A letter to the Ministry of Corporate Affairs requesting for an investigation to be undertaken under 210 and 212 or any other applicable provisions, and imposing punishment under 447 of the Companies Act.
Yes.
B. The parties, along with other shareholders of Nestaway, had executed a share purchase agreement pursuant to which Aurum was desirous of purchasing 100% of the shares capital of Nestaway, which included the purchase of outstanding warrants and cancellation of employee stock options against the bonus put out to identified employees of Nestaway. Pursuant to deliberations and discussions between the parties have mutually and amicably agreed to settle all interstate disputes arising out of the shared
Come to D. Come to D. This is
Yes,
the
Lord, I
ultimate.
was coming to D, Lord. On the closing date, yes, Lord. C, do D and C, Lord. Amar shall withdraw any complaints or petitions which
And
are
Amar shall withdraw any other complaint or
Yes.
action which are unknown to and or
so now, Lord, all of this. So this he had
Any
to
other-
withdraw everything. Now he does not withdraw it. Instead,
appearing for the informant.
Amar Sahu.
Yes, appearing for the informant.
what he does is not 4 months after the NCLT withdrawal. Please note, NCLT is 6 June 2094, not almost 4 months. He files an FIR on 23rd September 2024, making the very same allegations.
Yes.
And please note, Lord, while Odisha is a wonderful place to come, Lord, and as is Bhubaneswar, he invokes jurisdiction in Bhubaneswar, which is none. Because one party is in Mumbai, Aurum PropTech, the other party is in Bangalore. There is no nexus with Odisha, but he chooses Odisha as his playground. That's it. And Lord, I will just put it this way. I understand your Lordship has issued notice, but that was A5 was a company, it's Cheque Ventures India Advisors. I am an individual. All I'm saying is, you having withdrawn the NCLT petition, why, on what authority are you filing an FIR against us on the very same allegations?
Mr. Datta, there is no scope. See, you have already settled in NCL.
In fact, it's not.
And you have
settled.
said that you have to withdraw all the cases.
That is what Hub said. The settlement is, these persons are not parties to that settlement. If a Lordship see page 108, kindly see page 108 of that compilation. But we have a compilation because we have not received a copy of this application from them. Kindly see. I have to assist your Lordship. I have prepared a compilation. The documents which are with me.
You are a party, will give you a set, not a problem.
Kindly see that settlement agreement, Lordship see, parties, who are parties here? Amarendra Sahu, Nasanave and Aurum PropTech, they are not parties. They cannot take advantage of this document. So these people are not parties. And with regard to allegation, the statement that was made, kindly similar.
Yeah.
Page 108.
What is this?
Same thing. This is that same document referred to by my friend there.
The entire document.
Yes, sir. We have fished out it and filed it for your Lordship's kind assistance. Kindly similar page 108 of our compilation. Who are the parties to this settlement? And NCLT is only confined to operational mismanagement. That's all. But I'll also take your Lordship to the FIR specifically.
Who is he? Let us see.
Right, absolutely. So great. Kindly see.
He is.
Your Lordship got that page 108?
108, I am there.
Right, kindly similar to our parties here, this settlement agreement. This is Amarendra Sahu, me, the informant. Nestlé Technologies, the company of which I am the shareholder. Then Aurum PropTech Private Limited. They are not Aurum PropTech Private Limited.
They are what? Who?
They are not parties. Kindly similar.
They are also shareholder for this company.
Kindly
not the shareholders of Nestlé.
These kindly similar, Nestlé and Aurum shall withdraw any other complaint or actions which are unknown to Amar. But this is between these two parties only.
Where are you read?
Page 109D. C also Millard. C. Amar shall withdraw any other complaint action which are unknown to Nestlé or Aurum. These two only.
Yes.
And then next your Lordship will see in the FIR there is specific allegation against this petitioner, Lord. And cause of action we have given in the FIR, Lord. That's
all the parties are related some way or the other.
That in fact your Lordship will see in the FIR.
Why don't you settle? Why don't you think of for an arbitration?
To that I'll humbly submit. Your Lordship may take up all these matters on 18. We'll come back to
4.16 crores.
I think you should see NCLT you have settled. Parties are somehow related.
If they settle down our
I'll refer it to some arbitration or some proceeding and say
instead of arbitration, if it can be settled before my lords, I'll be happy. I'll be happy. We are not interested in litigation.
So therefore, why?
So take it up on 18.
Can I? You just tell me either arbitration or I'll send it to mediation.
My lord,
and do it. I'll stay the proceeding and try. And if something happens, then we'll think.
Tell you, there is no point in staying. There is no point.
May I just say this, just to add to what
even if I'll send it
your
to
Lordship, it can be over. Lordship may take up on 1812. We'll come back before your Lordship. Lord, it can be over before your Lordship also. Let your Lordship
come with some proposal.
Yes, ma'am, definitely I'll come. But
come with some proposal. They'll come with some proposal.
Three matters are there. We are not interested in litigation.
See, the end of the day, these are commercial give and take. We
are deeply grateful, my lord, and we'll come back on 1812. Your Lordship will consider the entire thing.
Okay, then 18th we'll hear it. And come with the proposal.
Not the only issue.
Nothing has happened in 2 days. What your Lordship has not.
My friend can't give that issue.
Happening now. Investigation is going on.
Lord, it's an apprehension.
May I just say this, Lord? May I just say one thing, Lord? My two things I must clarify. I'm grateful my learned friend has come with a very fair proposal that he wants to resolve. Just to clarify, Lord, Goldman Sachs is a party to the NCLT. The settlement takes place in the NCLT. So I think just a minute, sir, just a minute, sir. Just a minute. Can I just complete, sir?
Yes, what is said.
Second, Lord. He has received some 4.16 crores as against his shareholding. Now the issue is not, there was even in the settlement agreement also not, these matters could have been thrashed out through a commercial issue, whatever the reasons. Now your lordship has rightly guided both of us that we should try and resolve the matter. We'll look into it.
Come with some proposal. Come with some proposal. I'll put it them.
Yes.
To mediation and stay.
No need to send to mediation.
Mr. Mishra is in court, not Mr. Mishra is in court. Your lord, it is fallen to your lordship. We will abide by it. No questions. But the only concern I had was that though my learned friend appears for the complainant, I don't think he can speak for the police. For that, I understand the Deputy Solicitor General is there. The concern is this is an individual, not who's. There's an issue regarding his liberty. That aspect.
Well, be sure you instruct the IO not to precipitate the issue.
Let it come.
Not precipitate the issue.
There, but he's looking elsewhere.
I told the prosecutor he will speak. IO not to precipitate.
The Deputy Solicitor General.
Request to your lordship, through your lordship to Mr. Luthra, let them also come with a specific.
Yes, Mr. Luthra, I would only suggest you come with some proposal.
Yes.
I'll put to them, and we'll try to settle the dispute if possible.
Why not? Why not? These are
These are all commercial disputes.
Yes, sir.
I think you have started some venture because of the COVID and all. This might have gone wrong.
Big companies, my lord. Very big companies. They can take care of.
Might have gone wrong. And
my friend is preparing, it's bound to be a big company.
Because we get you, he's saying.
Very big shot, my lord. They can take care of us like anything. So I don't hesitate for that. My learned friend, Mr. Luthra, will come back.
Lord, we will come back to your lordship with something which will, I'm sure, satisfy my friend's client, and I'm sure my learned friend will also.
Finish it up. Why are you unnecessarily aggravating it?
Yes.
You come out with some proposal. So 18th, and I have instructed the prosecutor not to, precipitate it.
Yes,
not to precipitate.
All that ends well, no problem.
Not to precipitate it. Give instruction. Huh? Today itself, you give instruction.
But insofar as the role ascribed to each of the shareholders is entirely different. Chirete is the prime, seems to be the prime accused given in the FIR. My lord, we are entirely an investor. We came in, we have come out. My lords, my instructions, sir, my lords, some protection may be coming.
If I am saying the prosecutor will say till 18th, I am saying that.
Something or no court, something.
And Mr. Jana is there, he will speak to the IO. I know that, see, if I am proposing for settlement, if it is precipitated further, the scope of settlement is reduced. So therefore, I am very conscious of this. Therefore, I am requesting him to do that.
But I am hopeful my learned friend has understood my lord's mind.
Yes. Try to settle it. Why unnecessary? Because these are commercial disputes.
Right.
At the end of the day, sending you to jail, he will not be benefited.
Not at
Neither
all.
you will be benefited.
Not at all. Neither the suit, nor the litigation, nor the.
And he come out with the proposal.
Commercial got the same day FIR by lords within 4 hours.
So where?
Otherwise,
my lord also knows exactly.
Otherwise, you would not have agreed to settlement. So they brought you to the.
They'll address that point.
Yes. Come out with some solution, some proposal, so that I'll put it to them. If they don't agree, then I'll adjudicate on the merits individually.
Absolutely.
We will
18th and instruction to Mr. Jana not to precipitate and come with specific instruction. What is the stage of investigation? Okay.
So grateful.
Grateful.
8 months.
Last item. Last item. 2 more minutes. I'll just write next. I have 2 pages more.
You 5 minutes, the other side.
The other side is there.
My payment item 62. Only 3 to 4 days left in the next week, after vacation. 62 is the lawyer.
62 after vacation.
62 after vacation.
Item 72.
Stay order. Stay order to continue. Yes.
Item 72.
Yes.
My lords, here the interim maintenance of the petitioner has been stopped by virtue of orders of this honorable court. On, my friend is saying Wednesday or Thursday. Let it come up.
Let it come in the first week, Malad.
Last week
because
the interim maintenance has stopped.
No, that is to be adjudicated because your lordship has heard
Then
it.
let him pay something, your lordship.
No, I'm not entitled to pay you any
Execution
rupee.
case has been stayed.
I'm not entitled to pay you any.
While 125 K, the order remains unchanged.
No, that is not completely different in this subject.
No, what is the interim order?
Interim order, your lordship has stayed further proceeding of the execution case.
They are not paying the interim maintenance.
But I'm not entitled to pay. Your lordship has to hear it. And my entire grievance is she is not entitled to pay. After the decree of divorce, she is not entitled to
Well, the
pay.
interim maintenance has been confirmed till the Supreme Court,
Yes.
and even a divorced wife is entitled to maintenance until she remarries.
No, that is a direct Supreme Court judgment. I had placed this last occasion.
That judgment doesn't cover.
Problem, this is the case where divorce is granted with some alimony. And you, both of you have challenged the alimony part, divorce is accepted.
Divorce is accepted.
That is
Yes,
what.
my lord. Yes, my lord.
And whether once divorce is accepted,
My lord.
and whether you are entitled to maintenance or not, that is the question.
That's the question. And the section itself says that under 125, a divorced wife is entitled to alimony.
That has been clarified on the tax code that
Nothing has been clarified. What is the section?
25 application.
Section 127(2).
Permanent alimony.
And that 125 proceeding order is not upset.
No,
Is there?
they have not filed an application. They have not filed an application for variance of that order. And 125.
Where is that judgment you show me?
125(2) says.
272.
No, Joe, divorced wife. No, divorced wife. Order for maintenance, if any person, his wife includes the divorced wife. Wife includes a woman who has been, in the explanation, wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried.
That point was decided by the Hon'Ble Appellate Court.
Which judgment, let him show it, my lord. This is the statute is very clear.
Where is that?
Yes.
Which part?
Statute is very clear, my lord.
The statute says otherwise.
If your lordship sees 127, 125.
Your lordship
Wife
post it any
includes
day.
a woman
Your
who has
lordship
been,
post it any day.
who has been divorced by or has obtained a divorce from her husband
my lord.
and has not remarried. She admittedly she has not remarried.
Let my learned senior complete, then I will add.
No. I'm just placing my case, my lord. What the law is, and 127 speaks of alteration in allowances. He has to move an application under 127 for altering the or varying the order of maintenance, which has been upheld till the Supreme Court.
Here, this similar situation arose. That's why I requested your lordship that I'll place the entire judgment.
It is regarding the 25, if 25 2 is.
And this has been awarded under 25. Under 25.
My learned senior.
No, 25 permanent alimony, Hindu Marriage Act, if it is granted, whether it's, but that is not even today finalized.
No, Manoj, it's 17 lakhs I paid. I paid them.
No, but they are asking for, they are asking for enhancement.
Yes.
So insofar as permanent alimony issue is concerned, this has not been finalized.
No.
If the situation would have been reversed, a permanent alimony is whatever permanent alimony is given if the wife is accepting that. In that scenario, perhaps this judgment might have helped you.
Now we to place judgment as a full.
Put it Tuesday. This has to be decided.
let it be on Thursday.
Thursday.
19th.
Wednesday?
19th, because 17, 18, 16, there are 3 election cases at the end of it.
19th.
Interim order to continue.
No, that will continue.
19th at 3 p.m. my lords, because
3
maintenance.
p.m. Just see, this is the what is happening. And one heavy matter comes, then whole day goes. Yes.
Because the maintenance is stuck that.
I understand. That's the reason I'm. Yes. Yes.
Obliged.
$74. I don't think. तुम इसको देखिए एडजस्ट करो कुछ क्या करके ठीक है he'll give dates, he'll give, and rest of the matter is extremely urgent matter, then he will put it next week or